You put a little boogie in it. There you go. All right.
All right, and we're live.
All right, we're live with that one. A moment of levity for everybody here. All right. All right. Do we have quorum?
Yeah.
All right. Good afternoon, everyone. Today is Tuesday, March 1st. Welcome to the Judicial Proceedings Committee. We have, 10 bills on the docket? 8 bills now on the docket. We'll start off with Senate Bill 896. We'll then go to 763, 864, 866, 861, 819, 881, and then we'll end with Senator Jackson with Senate Bill 752. So with that, we'll start off with Senate Bill 896, and I'll ask Senator Lee to take the chair. Thanks. It's a terrible joke.
You want to bring your panelists up, Mr. Chair?
Sure, yes.
Okay.
I'll bring up the sponsor panel if that's okay. So I think it's the Office of the Attorney General. Come up. All right, thank you, Senator. So for the record, Senator Smith here to testify on behalf of Senate Bill 896. So you all remember our conversations last year surrounding police reform and independent investigations. And in our wisdom, we decided that those two things should be decoupled. So when there is an officer-involved shooting, we decided that there should be independent investigations. And we went forth, and in our discussions, we vacillated between where we should house this responsibility, whether it should be within the Office of State Prosecutor or with the Office of the Attorney General. We obviously settled with Senate Bill 600, which nests this responsibility in the Office of the Attorney General. And last year, the process that we established said that for the independent unit within the Office of the Attorney General would respond to and investigate all alleged or potential police-involved deaths of civilians, and that the law enforcement agency in the jurisdiction in which it occurred had to cooperate with this investigative unit for the investigation. And that once that investigation was produced, they had 15 days, once the investigation was completed, had 15 days to give that packet to the state's attorney in the jurisdiction in which the event occurred, at which point the state's attorney could then move forward with deciding to prosecute or if anything was necessary, any further action was necessary. So since the inception of this office, and I'm sure the Dana Mulhauser will correct me if I'm wrong, but I think there have been 12 cases throughout Maryland, 7 shootings, and then 5 other incidents. So on the operational level, there have been some technical and logistical problems with the way that we've kind of bifurcated this responsibility, meaning between investigation and prosecution if necessary. On one level, there are certain aspects that if, let's say, the prosecution wanted to offer, I know we talked about this a little bit, immunity to someone involved, that decision is kind of, again, bifurcated because the entity doing the investigation is separate and apart from the actual prosecutorial decision-making. That's just one little example, and you'll hear more of in the witness panel behind me. So what the bill does before you is that it sets up it gives the OAG the power to prosecute officer-involved fatalities if the local state's attorney declines to prosecute. So with the new process, within 15 days after completing this investigation, they again have to transmit this report to the jurisdiction in which it happened, obviously detailed investigative findings, and then whether the Attorney General recommends, whether this office recommends prosecution. The bill also clarifies language then in the current statute that this IID shall investigate all alleged or potential deaths of civilians, and that it similarly provides a mechanisms for resolving disputes. So if another law enforcement agency doesn't cooperate, let's say, that there's an actual a mechanism for injunctive relief so that it's clear that this responsibility is within the purview of this IID. So you have 2 amendments before you from the that you'll hear more about, and they'll formally enter them into for discussion. And one just switches the order. So right now, the way that the bill lays it out is that the investigation happens, and then the state's attorney has the first option to prosecute. If the state's attorney declines, then the Attorney General can step in and do it. So what the amendments does is that it switches that order, which makes more a lot of sense. And so what it does is, so first the OAG has the investigative piece, then they have the exclusive ability to prosecute that case. So it kind of switches it and takes the state's attorney out of the equation in that respect. This makes sense because they have to conduct the investigation, and then you remember that the way that the bill sets up, there's a 45-day period of time between when the investigation is given to the state's attorney and in which the state's attorney has the ability or to make a decision to prosecute or not. So 45 days is a long time to kind of sit before the attorney general would have the ability to step in and make another decision. So that makes sense. Second is that there's a language that would basically allow for the subpoena process. It would give this prosecutorial unit the ability to subpoena. And this is, you'll hear more about this from folks that actually do this every day, but in smaller jurisdictions throughout the state, they may not impanel a grand jury, or they may not impanel a grand jury consistently enough. That causes significant delays. And so if you give this entity subpoena power, that will make the process flow more smoothly, and it makes it more aligned to what the state's attorneys have right now. The state's attorneys have this ability to subpoena. So it just makes it more in line, gives it a better flow, and it seems like a logical division of responsibility in that respect. So I consider those two amendments to be friendly. With that, I will rest and take questions and then turn it over to the panel, but I ask the committee for a favorable committee report.
Any questions of the sponsor? Senator Bailey, and then followed by Senator West.
Mr. Chairman, how would it make more sense that the state's attorney have the ability to act in his capacity as the chief law enforcement officer, as the head of this, to all of a sudden be deemed null and void, right? That he would not have any say in this unless it came from the Attorney General. And the reason that I bring that question up is the state of Maryland, when we look at it geographically, when we look at what happens in Garrett County versus Baltimore City or St. Mary's County, it's extremely different. The people have the right to elect their own state's attorney, and that person is supposed to be a person that is elected and involved. And prior to this legislation has always been that person that has had the right to do that. I just think that I'd like your opinion on why you think this is a good idea.
So it's kind of like relitigating the argument we had last year just for the investigative piece, but I just lean on the Commission of Civil Rights. They came out with kind of the best practices for policing, and I'll just read this quote, and I think it's kind of been my North Star from when we started this conversation a couple of years ago. It said that the investigation and prosecution of use of force cases should be made as independent and public as possible. The agencies investigating and determining whether to move forward with prosecution should not have an ongoing relationship with the department. I think that's a good policy decision to ensure that there's not only transparency but independence, so that regardless of what jurisdiction you reside in, you know that there's a relationship, right? I mean, state's attorneys work with law enforcement, and when there's an officer-involved death, that should be decoupled, that should be kind of isolated or insulated from potential spheres of influence based on your prior relationship, working or personal or otherwise.
We'll continue.
Yeah.
Senator West.
Thank you, Mr. Chair. I don't think I have these two amendments you're talking about. I've got Senate Bill 896. My staff printed out everything that was available, but I can't find the amendments.
That's right.
Can we get copies of those?
You will have copies of it, and they will be drafted as formal amendments. Right now, they're just part of the testimony for the Office of the Attorney General. So if you look in your laptop, if you look at their testimony, I think there's draft language there.
Okay.
And yes, I think there is draft.
So we don't have copies of the amendments.
You don't have
at this
formal
stage.
amendments there.
And so I'm trying to get my hands around what you're suggesting, which is, it appears to me as if it would permanently remove from the state's attorney's office's prosecutions of these kinds of cases. It's hard for me to imagine that if the attorney general decides not to prosecute, that the state's attorney for the county would then override the attorney general's decision and decide to prosecute. If that doesn't happen, then it would appear to me my impression would be that, that the only prosecutions in the future of these sorts of cases would be handled by the Attorney General's office, with no involvement of the state's attorney's offices at all.
So that's what, if we adopt those amendments, that's exactly the scheme that would be set up.
Exactly.
Yeah.
Okay, thank you.
I did neglect to mention one thing. There was clarifying language on page 2 that, so before we talked about just officer-involved death, because we obviously didn't want to open up the scope to kind of every interaction, and wanted to narrow it down. But that has proven to be a little bit complicated, because what if someone is shot, for instance, but they linger for a couple of days, but it looks fatal, it's probably fatal, you don't know yet, they're not dead yet. And so if you look on page 2, there's clarifying language that it says the incident, and that's what injury to a civilian that is likely to result in death. So it's, lines 6 and 7. That's used, and you'll hear more of kind of the practical side of the house with a witness panel behind me, but I neglected to mention that, so thank you for jogging my memory.
Senator Castley.
Thank you. So I'm confused on page 2. It says that the law enforcement agency has to turn over police-involved incidents, which includes an injury that is likely to result in death. And so there's some discretion there. This talks about the responsibility for the investigating agency to turn it over. But then it says the independent investigating division, it's its discretion whether it's a police-involved incident. So we have, on the one hand, the investigating agency is saying, well, we have to determine this. But in determining it, I have to apply your standard. So how will I know to turn it over if I'm applying your standard? I'm not understanding that. They either have the discretion, which seems like it would be necessary. It's either a death, that's pretty clear, they're dead or alive, or injury likely to result in death. I assume that would be a medical decision that some doctor is going to make, tell people they're going to die. But then somehow, so if you don't, I'm just confused. Why would we have that be this other person's determining what the first person is supposed to be finding out? How's that work?
So I guess if I understand the question correctly, so we're obviously redefining what police-involved incident means. So the death of a civilian or an injury that is likely to result. I will defer that to the panel to understand the likely piece, but it's really the decision maker is what this is about. And that's important because they are then responsible for capturing the investigation and then subsequently the potential prosecution. But that entity, this IID, has to have that ability because of, and I think you're going to hear this later on, because of some of those instances in which there's not immediate death. So it seems to make sense to me. I mean, it flows to me, and I think it fixes an actual problem that's happening.
Rhymes with flows. What other thing I'm trying to understand with this is, I'm looking for that body of cases in the state of Maryland where we could not trust our local prosecutors to prosecute police cases involving a civilian death. I'm looking for that body of cases, and we're proposing an amendment to the law to greatly expand the Attorney General's subpoena powers over the citizens after our Constitution deliberately, intentionally narrowed it because we didn't want a statewide prosecutor reigning supreme over the citizens of the state of Maryland. So after we narrowed that, now we're going to roll that back, which one would presume we would do to address a serious and imminent problem. But I haven't found those cases, and I'm just looking for those cases where people said that prosecutors in the state of Maryland were turning a blind eye towards these problems.
So when this discussion was happening with the Office of State Prosecutor back in 1976, we had that discussion, and the voters voted on a referendum and changed the Constitution and gave that responsibility to the General Assembly to make that decision as to whether to expand the scope of that responsibility or not. So that's clearly within our purview to do that. Mm-hmm. And so the question that you're asking is a two-way street. Some folks, we're just arguing here, having a conversation, but we had last year. Some offices may say, look, we really like going after law enforcement officers on the force. We like that. Some jurisdictions say, I want to make my political bones by going after officers and showing that I'm tough on the force. Conversely, other jurisdictions may say, look, I'm someone that's always been pro-law enforcement. I've safeguarded this. This is subject to political whims or personal philosophy, but there's a connectedness there that if you put this in some separate entity that's disinterested, you have better outcomes. And I think the trust has better, the public has better trust in the process.
So
You
I guess I
remove
just
those-
reject this
those levels of
duality, this
influence.
sort of bipolar thing where we have either state's attorneys that hate cops and will always prosecute them, and state's attorneys that love cops never prosecute them. I haven't found that. I'm looking for those cases from somebody telling me that state's attorneys in the state of Maryland are unable to objectively look at law enforcement officers' cases. I know that it's not at all rare for a state's attorney or a sheriff to ask a neighboring county to come in and look because they don't want the appearance of not doing their job. But, you know, in the end, the facts come out in the civil suit because typically these are followed by a civil suit. And so you got the depositions and the trial. And I don't remember these cases where we then said, oh my God, look, the cops totally railroaded this, the state's attorney totally railroaded this one way or the other.
Well,
I don't remember reading those.
Senator,
I'm
I've
just-
heard, look, last year especially, I heard arguments that in a couple of jurisdictions in the state that some people argued that there were state's attorneys that were very interested in going after law enforcement officers. I've heard that line of argument.
Sure.
And that was a pretty prominent line of argument last
Yep.
year. Yes, I've heard that. And yeah, I mean, I know that Howard County, I think Howard County and Montgomery County were the only two jurisdictions that had like a formal MOU to do that kind of cross-jurisdictional investigation when something like this happened. It didn't prove to the satisfaction of a lot of the folks in Montgomery County, I'll just say that. Also, I don't know how you'd set up something like that statewide. You'd have to have some sort of, you know, these forced marriages between jurisdictions of varying degrees of like sophistication in terms of resources and population and kind of caseload.
Right.
I'm not quite sure how that works. This, to me, seems to be the most elegant solution. And frankly, with the 12 cases that have happened, I think you'll hear that it's been working well. But it just makes sense to have both the investigative piece and the prosecution
Okay, but if it's
within one
working
unit.
well, why are we amending it? We said we've had 12 cases, they're working well, but let's go ahead and radically change it.
The investigations have worked well, but the problems that I identified in terms of the decision points for prosecution, the handover of the case, the time that lags, and the sphere of influence is still there. And that's why this bill is important to kind of round out the circle
I'll
on
listen very
the reform.
intently to the testimony to figure out what that was. Thank you.
Any further questions? Seeing no further questions of the sponsor, thank you, Mr. Chairman. Now we'll turn to the panel. Attorney General Brian Frosch.
Thank you
You're
very
up.
much.
Mr. Chairman, Madam Chair, members, it's a pleasure to be here. You know, we have taken a hands-off approach to this issue in past sessions. There have been a series of proposals, give this authority to the Attorney General's office, give it to the state prosecutor, and then last year, okay, we'll give the Attorney General the power to investigate, but not the power to prosecute. And you know, so in short, we've not sought this authority, but I completely agree with the chairman, the sponsor of the bill, that it is probably the best practice to have an independent agency investigate and prosecute police-involved fatalities for two reasons. One, because it gives the public confidence that somebody who's not dealing with the police on a personal basis, on a day-to-day basis, who is independent, is going to take a look at it, investigate it, and make a prosecutorial decision based on what's right. It won't be any different in the Eastern Shore than it will be in Western Maryland or that it would be in Baltimore City. It'll be the same prosecutors and the same policies applied to the decision-making statewide. I think there is great value in that. As the chairman said, so far, this has worked very well. We've had 12 police-involved fatalities so far. We've worked well with every state's attorney whose jurisdiction was impacted by one of these incidents. We've worked well with the police in each one of those jurisdictions, and we've worked well with the Maryland State Police. But having the process bifurcated is cumbersome, difficult. We've received letters and complaints from some folks, law enforcement agencies in some of the counties who've not yet had an incident, but telling us that when it happens in their county, they're going to take charge, they'll collect the evidence, they'll interview the witnesses, and we can kind of follow along in their wake. That's not, I don't believe that's what the law says now, but the way this bill is drafted, it makes very clear that that's not the right policy. Once you've completed the investigation, it really, it's a waste of resources, and it's also, I guess, in conflict with the principle the chairman articulated, the quote from the U.S. Commission on Civil Rights about the independence of the investigation. We think if you're going to assign this responsibility to the Office of the Attorney General, that it ought to be a complete responsibility. We will investigate, we will prosecute, or we will decline to prosecute. We'll take the heat, but it's kind of, it's strange to have us do an investigation and then hand it off to somebody and say, okay, you guys make the call from here. One of the things that has made this effort successful so far has been the fact that we were able to recruit Dana Mulhauser. She is the chief of our independent investigations division. She is an outstanding prosecutor with many years' experience with the Civil Rights Division in the United States Department of Justice. She came directly to us from St. Louis County, where she was in charge of a unit that did precisely this. They investigated and prosecuted police-involved fatalities. She's got great experience, great judgment. She's an outstanding lawyer, and she has made this a success. She's going to talk to you about some of the technical stuff, and then we would be delighted to answer any questions that you have.
Good afternoon. It's nice to meet you all. My name is Dana Mulhauser. I'm the chief of the Independent Investigations Division at the Attorney General's Office. I feel privileged to lead a team of smart and dedicated attorneys and investigators who are specialists in this area and who prioritize independence, thoroughness, and transparency in doing our work. That said, the bill that created our division, like most bills that create most things, has some things that need clarifying. The first is this language of alleged or potential deaths, which we have all been working together to try to figure out what that means. And the challenge of that in reality right now is that there is no decision maker, right? It would be nice if there was a mechanistic way where we could say what that is, but the point is there's always some level of uncertainty, and somebody needs to decide, and right now there is no mechanism for figuring out who decides, and we don't want to have that argument at a crime scene. The second thing this bill does is it provides a mechanism to resolve disputes if local law enforcement agencies attempt to interfere with or harm our investigations. Although the vast majority of local agencies have not attempted to do that, we would be naive and we would be irresponsible if we did not provide a remedy for if they tried to do so. The third thing in terms of cleanup that this bill tries to do is the friendly amendment that the chair mentioned, that would provide this office with subpoena power, direct subpoena power. So that is no change in terms of substantive authority. We already have the authority to get subpoenas through grand juries. The problem is that some counties don't use grand juries, and so when we bring them these subpoenas, they don't know what they are, and it can take several days or even a week to get that sorted out, and that is time that our investigations cannot afford. So for these reasons, we ask for these amendments, and this bill passed, and I am happy to take questions.
Yes, thank you. I guess whoever wants to answer these questions would be fine. So there's 25 cases that were referred, I understand, for the testimony, was there 25 deaths, or what was the breakdown on those?
Well, Senator Castle, I think you may be referring to the letter from Sheriff Gaylor in Harford County.
I'm just listening to your testimony. I
We
thought you said
have
there was 25 cases referred.
12.
Maybe I misspoke.
Yeah. There've been 12 cases.
12 cases,
of
okay.
Officer-involved fatality.
All right, 12 cases that have been referred to your office.
Correct.
Okay, and they were all deaths?
Yes.
And what jurisdictions?
Baltimore City, Howard County.
We've had two in, let's see if I can do this off the top of my head. We have had 2 in Baltimore City, 2 in Baltimore County, 2 in Anne Arundel County. We've had 1 in Charles County. We've had 2 in Montgomery County. That gets me to 9. Oh, we had 1 in Wacomico County. I apologize that I don't have the, we had 1 in Frederick. That gets me almost all the way there.
Okay.
Howard. No, we haven't had 1 in Howard directly.
And how many of those have led to the prosecution of law enforcement officers?
So we have just started these cases in October, and so as I'm sure you have read, the Office of the Chief Medical Examiner is backed up, and so very few of these cases have had their investigations completed, and certainly none have gotten to the point where the state's attorney's office has either prosecuted or declined.
Okay, and are any of them being pursued by you all at this time?
So we don't have the authority to prosecute them.
Right, but you would reverse that, so this decision would be yours in the first place, right?
I think that having it be independent is the correct decision, yeah.
Right. Any problems in working with these 12 cases so far?
You know, I would say that there have not been problems we have not worked through. Obviously, in any new process, there are things that need to be worked through, but I will say that the law enforcement agencies that we have had cases with so far have really been not only cooperative, but understanding of the need for this independence. And I would even say in many cases, appreciative that this independent review exists.
And how many people, Ms. Molson, how many people in your division?
So we have 9 people in our division, plus a couple we borrow here and there.
And what are those? What's the makeup?
There are 4 attorneys, there are 5 investigators, and then we also have partial assistance from a victim witness coordinator and a public information officer.
Okay. So do you know how many police-involved deaths or police-involved shootings there were last year? Do we have any data on that?
So our expectation when we began the year, and again, we don't just have shootings, we have all fatalities as well. So our
Right.
expectation was about 30 to 40 cases, and we are roughly on track for that because crime is always higher in the summer, and therefore we expect these numbers to go up in the summer. So the fact that we took jurisdiction in October is actually in some ways a blessing for us because we were able to start at a time that was a little bit quieter.
Right. I mean, I guess it's interesting. I think we had like 600 murders in Maryland last year, and we're putting a special unit. We've had a really terrible rate, particularly in Baltimore, of resolving those. And it's torn the city, pretty much rendered Baltimore a shell of its former self. Economy destroyed, schools unsafe, streets unsafe. Nobody goes there anymore. And yet, we've stood up a special division to go after police officers. I'm still baffled on the sense of priorities here. It just has me totally flummoxed, so you have to excuse them. I'm really trying to understand this.
No,
okay?
I appreciate
because
that.
Because I just find it so bizarre that we're doing this, but nevertheless, I'll go along because it seems so totally out of touch and devoid of reality.
May I address that?
Sure.
So we're not actually going off after police officers. So the goal of this unit is to investigate police officers in the same way that rape is investigated, which is to investigate them by someone who doesn't know them, who doesn't work with them, and who provides a disinterested investigation. So all we are trying to do is provide an investigation that matches what hopefully the city of Baltimore and other places are already doing, and we're certainly not trying to take funding away from any of them.
Right. Now, I find it interesting because I think it was the Attorney General's comment that it's sort of a discussion that, hey, because it's a statewide effort, it's sort of above prejudices of the locals on the locals. You get the same interest in Baltimore and the Eastern Shore was the statement. But just ask you, so if the Attorney General is overwhelmingly in the state of Maryland, elected by Montgomery County, Prince George's County, a combination, of Montgomery, Prince George's, and Baltimore City. And pretty much doesn't matter what the rest of the state votes. If you can get those three, perhaps Baltimore County, then he's free to totally disagree with the rest of the state. So how does that, you're talking about the appearance of fairness. If the majority of state, if the Attorney General has the ability to be totally biased in favor of those 3 or 4 counties and totally just rain hell on the rest of the state at his whim, does that create a sense of, I'm just wondering how you all see that as creating a sense of fairness and transparency and confidence in the system?
Senator Casserly, I don't see it that way, and
I think that's a political reality, Mr. Attorney General, that you can disregard the rest of the state.
Anybody, any elected official could do that.
No, only you can, honestly. In all honesty, you're the only one that
I mean,
can
any
do that.
elected official can ignore his or her responsibility and say, I'm just going to do it the way I want to do it. I don't care what anybody else thinks. The Attorney General is elected to say, well, look, I got 65% of the vote. I'm pretty sure I got a bunch of votes from Hartford County as well as Carroll County, the Eastern Shore, and Western Maryland. Anybody who's running statewide is going to be attentive to the people across the state. And any Attorney General is not going to have a day-to-day relationship with law enforcement officers in a particular jurisdiction. The state's simply too big for that. So in that sense, the Attorney General is a good choice, I think. I think you all toyed with the idea of giving it to the state prosecutor last year and decided not to. But somebody who is removed from local politics, I think makes sense when you're talking about law enforcement fatalities in which local law enforcement is involved. And I think we have the ability to attract and retain highly qualified people to do the work. We're not here advocating that we're going to do it better than the state's attorneys. I've stayed out of that until this year, and the reason I'm here testifying in favor of this bill is because I think it makes sense to unify those two functions, the investigatory function and the prosecutorial function. It's kind of crazy to lop it off in the middle and say, you do the first half and then you do the second half. The functions are integrated in every other criminal case in our state and pretty much around the country. And I think it makes sense to have them unified here.
Okay, we'll just agree to disagree on that. I mean, all politics is local. You rely on local politics. Pulling it from the state's attorney to your office does not take this out of politics. It's just as much subject to political shenanigans either way. But let's move on. I'd just like to ask you about how this does work. So we've had at least 12 test cases here by your count. I'm just curious how it's going. Basically, what happens? This thing comes in. How does the process flow?
Let me let Dana answer.
Thank you.
Sure. So we do have a partnership with the Maryland State Police, which is very helpful for us because they have certain statewide resources that we don't have, right? The Attorney General's office does not have drones, for example. So one of the things that the state police has is a call center. And so we have promulgated protocols that all law enforcement entities within the state have, that when there is a potential fatality or a fatality that they call this main number that is staffed 24 hours at the state police. As soon as they call that number, there is a phone tree like you wouldn't believe that the state police gets activated and our office gets activated and our investigators and our attorneys come out in the middle of the night, as do the state police homicide detectives, the crash team if that's appropriate. We use the state police lab, and all of those folks get there as soon as they can. One of the things that is in our protocols that local law enforcement has generally been quite good with us at is figuring out how that handoff should work, right? Because local law enforcement is going to be the ones who are there when it happens, and so we have processes for figuring out what evidence they should be collecting, what evidence they should be waiting for us to collect. And again, I think because of communication among the parties, that has gone very well. And then there is a process of beginning the investigation. And so there are interviews of witnesses, there are reviews of cameras when those exist, and all of the other steps that occur during any law enforcement investigation. And while that is happening, the lawyers in our office are beginning to do the legal analysis and the factual analysis of the case. And so they are beginning to write up the report that the statute calls for. And then when that report is completed and all of the lab results are in and the analysis is in, that report gets turned over to the state's attorney's office, and then it is out of our hands.
Okay, so we've got 12 in, you've only been open since October, right?
We've been what, sorry?
You've been up since October, I think you
Yes.
said? You got 12 cases in, so I assume you're potentially, and you say you're still investigating all 12 cases, so.
No, we have one that we've completed.
One you've completed, okay. So these are taking at least several months, it looks like, to try to clear a case. You've got 9 people on a team versus each county having dozens of people in the major counties, and every county having some throughout the state. So we're putting a 9-person team on the entire state versus the entire criminal investigation sections of all the local jurisdictions combined. But we're going to, how is that supposed to work? When I look at the ability to have on scene in that county, I mean, most of our counties now have these amazing mobile crime units. They've got tons of officers quickly to respond within minutes to be there and begin the investigation and secure the scene and start securing the evidence. How does that work? Because you're bringing in 1, 2 investigators, 3 maybe, versus the entire investigative section of that local police. So I take it, are they now sidelined? You come in, they stand back, or they stand back when they call? What's the arrangement?
So that's a very good question, and that is why we spent so many months developing those protocols, and it has worked out very well. So we are fortunate to have the assistance of the state police, and the state police have many more than 9 people, and so they do respond very quickly and in good numbers to these scenes and are able to work with us and be partners with us on these scenes, again, including their various specialized units. And so when we come to these scenes, we do come prepared with the number of people who are there to address them. As you yourself noted, although this state and local although local law enforcement has many more people, they also have many, many more crimes than we do. And so proportionately speaking, while of course we do want and would like to have additional resources, we do not feel that we are ill-equipped to handle the cases that we have.
Under this bill, there's been a shooting, is the local jurisdiction loses, the local police loses jurisdiction, they can no longer investigate this matter?
One of the things that we are trying to figure out is exactly how that works. So right now, the vast majority of jurisdictions have said to us, in line with the aspirations of the original bill, that yes, it is better for this to be investigated independently, and have voluntarily stepped back. There has been at least one jurisdiction that has said, no, we will not step back, and we're concerned about that, because there are ways to interfere with an independent investigation that can mess it up, and we are trying to make sure that doesn't happen.
But
All right,
don't you-
Senator Cassidy, we'll get back to you. I just want to make sure I've enjoyed the colloquy, been very informative, but I want to make sure other members get a chance, and I'll come right back to you, okay? So we'll go to Senator Huff, we'll go to Senator Bailey, then Senator West, we'll come back to Senator Cassidy.
Yeah, thank you very much. What was the one jurisdiction that you've concluded?
We have had a case in Wacomico County where we have sent that case to the state's attorney.
This is interesting because I see in Frederick County, they had 2 police officers were shot, and then they shot the offender. And within a week after the shooting, the state's attorney, it says, I'm looking at the headlines right here from the Washington Post, Frederick County State's Attorney concluded that 2 Frederick City officers were justified in shooting a 25-year-old. So, and by all, I think that was correct by everything I've seen. They watched the body camera. The person was walking away from them. They got a call. There's an erratic person with a gun. He's walking away. I know you can't comment on it, but just the committee knows. He's walking away, and he just turned around and started shooting and shot both of them. And luckily, they stopped him, and he was shot, so he didn't hurt anybody else. But how does that work? Because now the Frederick County State's Attorney said, we watched body cameras, justified, we're not prosecuting. Then you could come back in 3 months from now and say it could be prosecuted.
So that's not our case, because that individual, if you're talking about the case, I think in about 2 weeks ago in Frederick,
Yeah.
so that individual did not pass away, and therefore that's not our case.
Got it. So they have to actually be deceased in order. But have you had other, well, thank you for that clarification. That makes sense to me now. Have you had other cases where the locals have already declared one way or another what they're doing, or they're all holding off until
They have all held off.
they've held off? All right, that's my question. Thank you.
I think though, in clarification, that's one of the amendments, though, if there was a serious potential. Is that correct?
So the current law is death. So one of the amendments to address an issue of someone that you can, I mean, we can explain, that languishes or lingers, that's probably going to die, maybe, we don't know, addresses that kind of gap because there have been some circumstances.
Yeah, so there is one jurisdiction that has said to us, look, if the person's still alive, we're doing the investigation. Dies 3 days later, okay, you can take it over from there. But the point is, it's extremely important to get to the scene, collect the evidence, interview the witnesses. It has to be done as quickly as possible, or many of the investigatory functions have to be done as quickly as possible. I'm sure you know this, Senator Bailey. The Frederick County case is an interesting one, because I think Dana got up in the middle of the night, some of our folks did, and started driving to Frederick County. No, I guess it was the afternoon. Started driving to Frederick County, and the person made it to shock trauma, or made it to the hospital. I think he was hit 4 times in the torso and survived. Not our case. But if somebody said, well, look, I know he was shot 4 times in the chest, and he's probably not going to make it, but he isn't dead yet, so you're not getting into it until we do. We think that's a serious problem, and we don't think that the law says today that that's the way it works, but we want to make it absolutely clear that if the person is likely to die, we'll continue investigating until it's clear that the person survives.
So my question, sir, is to you, Mr. Attorney General. I know that, and I mean this with no disrespect intended, the fact that my constituents that live in my county, they do not want to live in a more urban area. They don't want to live inside that beltway. That's why they moved there.
Sure.
They don't want to live in the city, right? They want to have a relationship with the prosecutors, with the police. That's what they have, right? And the question that I have is, how do you feel that, I've worked with your office, well, not actually with your office, with your predecessor, from the law enforcement perspective. And quite frankly, the Attorney General's office did not have the resources to help us investigate criminals, especially large criminals and businesses. They never had the ability. They would come out, they'd be all geared up, they'd be there ready to go, and then they'd turn around and say, you know what, we don't have the budget, we don't have the ability, it's got to be handled locally, right? And that's the way and I've been retired for quite a few years, so I didn't have the opportunity to work with you. But that's what I've seen from the Attorney General's office personally. And I don't understand this, that all of a sudden we're saying, wait a minute, we don't have the ability, or at least I didn't see it, where they had the ability to investigate criminals. They didn't have the ability to help all the people that lived in these rural jurisdictions. But now, wait a minute, as a policeman that was involved in something, we're coming down and we're investigating that. And by the way, we've got all the resources and the ability to do this the right way.
Well, let me say, Senator Bailey, that one of the first things I did after I was elected was to set up an organized crime unit. So we put resources into prosecuting the most dangerous people in the state. I mean, we did an indictment, series of indictments last week, where we had a gang that had 5 kilograms of fentanyl It takes, I think, 1,000 micrograms of fentanyl to kill somebody. For a kilogram, you can kill 1 million people. So 5 kilograms is a lot of potential death. Our organized crime unit has prosecuted and indicted, prosecuted, and put behind bars hundreds of folks who are extremely dangerous, violent and dangerous. So the capacity of the Attorney General's office, and it's a small unit as well. I think we have 8 or 10 lawyers at this point. But we've changed the ability, the capacity of the Attorney General's office to deal with violent crime. That said, this responsibility was not responsibility that we came in here asking for. It was a policy decision that you all made. We're happy to take it on. We'll take any assignment you want to give us. But we think that it shouldn't be bifurcated, that the law enforcement agency that does the investigation should also be the law enforcement agency that does the prosecution. And, 9 people probably isn't enough for a caseload of 40 difficult, complex cases a year. I think we're probably on track for more than 40 because, we've had a bit extra in the winter months, and we expect it's going to be worse in the summer months as it gets warmer.
So, and I guess that's my, whole point, is if we're going to be doing this, right, the resources should be there. But in dealing with, my dad was a state's attorney. Good friends of mine have been the elected sheriffs. When they had the opportunity to have a question for any one of their officers working in the county, they picked up the phone, they got the answer instantly, right? Something's happening today, you pick up the phone, you call the state's attorney, this is the way we're handling that issue. That's the way it works in these rural counties, right? Are your officers, or do they have that same responsibility and that same ability to deal with these police chiefs and these sheriffs?
Well, yes, they can get to the police chiefs and sheriffs, but you're right. We don't know the individual officers in St. Mary's County or in any other individual jurisdiction. And look, there's a policy question here, and it's essentially the one that Chairman Smith read to you from the U.S. Commission on Civil Rights. And the policy question is it better to have somebody who is removed, who doesn't know personally the folks that are the subject of scrutiny? Look, I can tell you, there are very few instances in which there's a police-involved fatality where the police officer is going to get prosecuted. I think that's true whether they're in St. Mary's County, Carroll County, Baltimore City, or anywhere. But the principle that the chairman cited is one that it's important for the confidence of the public to understand that the review of that case is going to be done by somebody who doesn't know that police officer, doesn't go to the Chamber of Commerce with his wife or her husband, and doesn't go to church with the officer and live down the street from him. It's going to be done by an independent agency, and the review is going to be independent and not based on any kind of personal relationship.
I can just say, in the jurisdiction I live in, right, we have many more people than what we have police officers, right?
Yeah, sure.
Those people clearly go and elect the state's attorney. They clearly pick that person. They don't pick that person on how, in the relationship that a police officer has with that attorney. They pick the state's attorney on how that person will deal with crime and in the streets, and how their family's going to be safe, and how their children are going to be safe. Quite frankly, a lot of them don't even vote for people in your position because they know their vote doesn't matter. But they know their vote matters when they're at the local level. Removing additional things and putting things into your office, I think this is an overreach.
Every vote matters, Senator Bailey, every vote. All right, Senator West.
Mr. Chair. So this is an interesting bill. So let me ask, first of all, you say only a single of these investigations has been completed, and that one in Wycomico County. What's happened there? Has the investigation report been tendered to the state's attorney's office, and what have they done with it?
So the investigation report has been tendered to the state's attorney's office, but we are bound by confidentiality rules not to tell you anything else about that investigation. The statute says that the report remains confidential until a prosecution is completed or a prosecution has been declined. And since neither of those things have happened, then we can't talk substantively about it.
Well, that's interesting. So we're not allowed to find out what your report recommended? And
Well, I should say that one of the goals that we have put in place is transparency, and so we have pledged internally that within 30 days of the state's attorney's office making their decision, whatever that decision is, we will make our report public. So that
Okay,
will become
but-
public, but we cannot make it public yet.
But you're saying they haven't made their decision yet, so they're still within the 45 days they have to make the decision?
So the current statute does not limit their period of time to make a decision. So they have as long as they would like, or as long as the statute of limitations would apply.
Okay. Well, as I read this bill, I liked the bill. It's the amendments that it caused problems. So the bill itself requires them to make the decision within 45 days, right?
The new bill,
The new
yes.
bill, yeah,
Yes.
right.
That's because there's a carry-on, there's another step to the prosecution, there's another entity, their office would follow the state's attorney at that, under that bill.
Right.
Yeah,
Yes.
that's why there's no 45-day declination in this current statute, because there's no second step.
So I want to continue and ask about independence. The Attorney General emphasized the importance of independence and the public knowing that someone who's genuinely independent, or an organization that was independent, was going to be making these decisions. But I started to scroll through the Maryland Manual, and it didn't take long for me to come to the part under the Attorney General's office, which covers your unit, and it just lists you as the chief. And I think the Attorney General said there were 3 other lawyers who were in the unit now, so a total of 4 of you?
That's correct.
So you're a lawyer, so that's 4 lawyers. I would guess in the Baltimore County State's Attorney's Office, there are 40 lawyers. And the Baltimore County Police Department has all the forensics needed to analyze. Do you all have forensics in your unit? Are you able to analyze blood samples and all that kind of stuff?
We do. So I should start by saying we have a much lower caseload than the Baltimore County State's Attorney's Office does. And so I think on a per attorney, on a caseload basis, and I can say one of our attorneys came from Baltimore County and has a much smaller caseload now than he has when he was at the State's Attorney's Office. So on a caseload basis, I think folks have the breadth and the time to work on it, and we do. We are very lucky to have the Maryland State Police Forensics Unit that has all of.
Okay, so Maryland State Police Forensics.
Yes.
It's not your office. It's not the Attorney General's office that does this.
No, but we are partners in this, and so we meet with them very regularly, and they answer any question that we have. And it is no different for me personally than when, for instance, I was at the Department of Justice and I would need to consult with the FBI lab, right? It wasn't necessarily my office, but they were our partners in that process.
But my point is, you are relying on work of the Police Forensics Unit. So to that extent, you're not independent. You're relying on information provided to you by the police. Isn't that correct?
You are right that it is impossible to do a law enforcement investigation without involving some law enforcement officers, right?
Right.
There's no way to do it.
So you're not totally independent. You're
No, but
relying on the police.
we are
for-
the best that we can do.
Right.
It's the state police, so not the police within the jurisdiction, which
Yeah,
you've
I
heard this said.
understand, but it's
All right,
it's
that's-
still the police.
I just wanted that for the record, though, just.
Yeah, okay, I think it's, yes, it's the Maryland State Police Forensics Unit that helps you. So the main point I want to reach, and I guess is really more with the Attorney General than you, and that is, many, many years ago, I got involved in Dick Bennett's campaign for Attorney General. This is back in 1994, so it's really dating me, and probably many people here on the table don't remember that, but you and I do.
Yes.
And we were discussing what the issues should be, and somebody said, we ought to make violent crime the issue. And our response was, we can't make violent crime the issue because the Attorney General of Maryland really doesn't deal with violent crime. So that should not be the issue of the Attorney General's campaign. This was a campaign against Joe Curran, as I recall.
Right.
So violent crime was simply not involved in the campaign. And so I've been making my way through the Maryland Manual, and it appears to me as if other than this organized crime unit that you mentioned that you started, the Attorney General's office still doesn't get involved in violent crime, to any
Well-
kind of a reasonable extent, isn't that correct?
Well, the organized crime unit is the unit that deals with violent crime. And it's a small unit, but it's punching way above its weight.
Well, but it's organized crime. You don't get involved in a police shooting of up until this
No, we don't.
point,
No,
to individual shootings of
No.
people, that kind of thing.
that's absolutely right, Senator.
Right.
And I just got to point out that poor Judge Bennett's career went straight down the tubes after he lost that election, right?
He ended up in a far better position, I think, than if he'd been elected Attorney General. He's been a very happy U.S. District
would
Court
think so.
judge, and still is a good friend. So, but here's my concern. If we start giving the Attorney General's office violent crime responsibilities, isn't it likely that future Attorney General campaigns will devolve into arguments over violent crime? And isn't it likely that these are areas which they have never involved before, that we're going to have charges that he's soft on crime, he's too tough on crime, he hates policemen? Aren't they likely to become the warp and woof of an Attorney General's campaign in the future,
Yeah.
which will totally change how the people of Maryland regard the office of Attorney General?
Well, you know, I've only run for Attorney General twice.
Right.
I'm pretty sure I'm not going to do it ever again. And both times, violent crime was one of the themes that pervaded the campaign. And especially when I first ran, the Attorney General's office had very little to do with violent crime. We did see a need, and we had the ability to put together this organized crime unit that's been very effective. But no, I mean, I don't think the Attorney General should be. The Attorney General of Maryland should not be involved in, you know, the day-to-day crimes, even violent crime, unless it's organized activity, unless it's gangs, unless it involves something more than, you know, one. I mean, we've had a couple of murders that have that we've solved as a result of our investigation of some of the gangs. Sebastian Dvorak was a bartender in Baltimore City, going home on his birthday, robbed, shot, killed, and in an investigation of his gang, we found out that he was one of the ones involved in the murder, and he's been convicted. But no, I agree with you. That's the job of the state's attorneys. It should be the jobs of the state's attorneys. The General Assembly made a policy decision last year that the Attorney General's office should be involved in the investigation, and that doing it independently of the local law enforcement was important in this limited slice of cases. And I think while we didn't come in and support this bill last year, in fact, I think we wrote a letter of concern. I think it was a wise decision in retrospect, but I think unifying the two functions is critically important.
Well, let me just finish by saying this. These cases against policemen are extraordinarily controversial.
Yes.
And polarizing, and they occupy the headlines in the newspapers.
Yes.
I am concerned that if we turn over the prosecution of every one of these cases, and you indicated earlier that it's likely that if this bill passes as amended, that there will never be state's attorneys who prosecute these cases anymore. It'll just be the Attorney General. That we're going to find that Attorney General campaigns will turn in the future over prosecutions of policemen, either pro or con, and it will totally change, I believe, how the citizens of Maryland regard the office of Attorney General.
I mean, I think any candidate for Attorney General would have to walk a very straight line on that. I mean, first of all, I think it's inappropriate to say that, you know, there's too much prosecution of police officers or there's too little prosecution of police officers. That should not be the subject of an Attorney General campaign. It may be, but look, I mean, let's say there are 40 cases a year in which a police officer is involved in a fatality. My guess is that in 36, 7, 8, 9 maybe even all 40 of those cases, you're going to find, as the state's attorney from Frederick County did, not, it's not at fault. This is part of what comes with the job of being a police officer. You got to defend yourself. You got to defend other folks. And I think an attorney general, and this isn't going to be me. I mean, if you pass this bill, my office might have 3 months, with me as attorney general of implementing it. So it's not like I'm here saying, give me more power. But I think that an attorney general is less likely to get swept up in local politics in dealing with these issues than is a prosecutor who's going to face a constituency that is either demanding prosecution or demanding that the police officer be vindicated. And I think an attorney general is more likely to be able to withstand that kind of political pressure.
Thanks for your answers to my questions.
Thank you.
Senator West, did you go to college or law school with Judge Bennett? He's a Penn grad, so.
No,
See West.
No, actually, he went to the University of Pennsylvania
For undergrad.
for undergraduate. I went there as for law school, but we weren't there at the same time.
There you go. All right. Let's do Senator Casserly and then Senator Bailey.
General, just finishing up with what, I'm sorry, I'm trying to grab you before you,
Yeah, that's okay.
before you sat down.
I need the extra.
The prosecutor's, the prosecutorial decision, Ms. Mulhouse is the lead, I guess, prosecutor on this, is that
Yes.
the time? But now she gets Officer Jones. Who makes the decision to prosecute or not prosecute?
Well, it would be Dana Mulhauser. but-
Mulhauser, I'm sorry, I
Yeah, no, that's
screwed your
okay.
name up.
But I would expect that any decision to prosecute would come to the Attorney General. I mean, they would say, okay, here's what we got, here's the investigation, we would like to prosecute, what do you think? Now, that happens, that's pretty much the way it works in our organized crime unit. If they're about to indict folks, they let me know, they tell me what the charges are, what the facts on the ground are. And I can't think of a situation in which I've said no.
Well, the one, I think, that we talked about one case being completed. Were you consulted in that one?
Yes,
So ultimately, you're the guy who said, don't prosecute?
yeah, they gave me the facts, they gave me a memo, the file. I said, looks good, send it out.
Okay, thank you. I have some more questions for Ms. Mulhauser, if you don't mind. You and I, we were in a line of discussion about, an investigation's ongoing, and you had talked about deploying your people out, and we had gotten down, we were having a discussion about interacting with the locals and how that works. You mind just continuing from there, if you remember where you left off?
Sure, I don't know that I stopped in the middle, but I can give you more
Okay,
detail,
please.
and you can tell me which part of that is helpful.
Okay,
So, there's just there are a lot of phone calls back and forth, and some of this is done in a preparatory way. Our chief investigator and I and other members of our staff worked as hard as we could before this even went into effect in October. So I started in August, as did our chief investigator, and we have met with every member of local law enforcement who will meet with us. We do in-person roundtables. We have traveled to all of the larger and many of the other departments to meet with them, so that, I always say, if someone has a question, I want them to ask it to me rather than wait till I leave the room and ask it then. And so as much as possible, we have tried to sort of get that in motion so that when these things happen, folks have each other's phone numbers and they know how to reach each other. And so, because a lot of decisions do have to be made on the fly. Should we preserve this piece of evidence? Should we let this go? How soon are you going to get here? When is the evidence team going to get here? So a lot of that gets worked out as the case proceeds.
Is it fair to say that in every case, the locals have already begun an investigation when you hit the ground?
I don't know that I would call it an investigation. So what we ask the locals to do is to preserve the scene as best they can. And there are if the choice is between having a piece of a piece of evidence, and a piece of evidence can be a person, right, including a witness. If the choice is between having a piece of evidence disappear or the locals collecting it, then obviously we would prefer that the locals collect it. If it's an evidence that's not going anywhere, if it's a bright sunny day and the weapon is sitting there on the ground, then we ask them to just control the area, and then the independent investigation can collect that weapon and make sure that that is done independently.
I mean, I just thinking, I'm not a police investigator, I'm not a prosecutor. I would just expect that as soon as an incident happens, massive police presence would come because there was a police-involved shooting. Every jurisdiction is gonna employ massive presence there who will secure it, probably start photographing everything instantly, click, click, click. Photographs are electronic, so you can photograph, that's an investigation. They'll start looking who's there, identify people, taking names down, addresses, anyone within an eye shot radius all the way around, start looking for video cameras instantly.
So some of, if I may, some of that is right and some of that is not quite right. So they won't necessarily begin to photograph or begin to speak to witnesses again if that can be held off. And, our folks are usually there within an hour or two. So, witnesses, for instance, are sometimes taken back to a police station in order to wait to be interviewed by our investigators and investigators at the Maryland State Police, because we do think it is important to the extent possible to have those interviews done by the independent investigator. So that is what usually happens, is it is preserved and then that's done an hour later.
Okay, so, and you had one in Wycomico County, you got Baltimore City. Are you using the same people they deploy from the center of Maryland out, or do you have people forward deployed around the state that you use?
We have people all around the state, and some of that is because the Maryland State Police have barracks all around the state, and some of that is we have made a deliberate effort in our own hiring to be diverse in many ways, and one of the ways we have tried to be diverse is geographically, so that we do have people in different areas and from different areas.
So you arrive on the scene. What's the furthest that you've seen the locals go before you're there?
I don't want to get too far into a specific of a case, but we have, it has been very cordial, right? And I think that helps. Cell phones are great, right? So our chief investigator and our deputy chief investigator and the folks at the state police always answer their phones. And so we have urged the local law enforcement as much as possible, if you have a question, call us and we will figure out a solution that is reasonable.
So under the bill with the amendments, as I understand it, and maybe I have it wrong, the locals would basically lose jurisdiction on a police-involved shooting. Is that fair? Is that correct?
So I think in practice, it would not look different for any of the 12 cases that we have had so far. What it would mean is it would stop a jurisdiction that essentially wanted to interfere with our investigation and would stop them from doing that. None of the jurisdictions so far have said we want to do a competing criminal investigation of the officer. I think because they've realized, like this body realized, that that's better when it's done independently, but we are concerned that an agency would try to do that.
We're still on our first bill and our first panel of our first bill, so I don't want to disrupt the flow of fact-finding, but if you could, we can do some follow-up, some written questions, but I do want to just move along a little bit because we've got Senator Bailey. If you could please be succinct, and then we can go into the next panel because we've got a lengthy list ahead of us, so.
Okay.
Thanks.
Just as this implication of this bill when we're talking about local prosecutors, right? And as we talk about the local prosecutors and we talk about potentially expanding this bill, the whole implication is that these prosecutors might not do an adequate job in the prosecution of this case, right? And we referred to something that the chairman read, and we said that's the whole implication. We want to make sure. So my question is, what does this say about the prosecution of an offender who kills an officer? Because clearly, if they're not going to be hard enough on the person, they're not going to do the correct investigation on the person who who shot at the officer, who the officer killed, right? They're going to say that's the officer. The defense, the attorney is saying, well, the officer did the right thing. What happens vice versa? Won't that give the person prosecuted an automatic defense? Will we change this?
No, I don't think it does, unless you change the law and say, for some reason, the Attorney General should prosecute everybody who kills a
Well,
police officer.
That's what I'm getting at. I mean, if that's the implication that we are saying that this bias exists for these local prosecutors, and we should expand this, then it should go both ways.
No, I mean, I don't think that follows, Senator Bailey. With all due respect, I mean, nobody is suggesting that we go easier on murderers. I mean, police sometimes kill people in the line of duty, and sometimes it's necessary. They're doing their jobs. They save somebody's life. They save their own lives. And I mean, the principle that Chairman Smith enunciated is the one that drives the question about who should prosecute those cases. But I don't think anybody would suggest that someone other than a state's attorney should prosecute somebody who kills a law enforcement officer.
Okay, thank you.
Thank you very much. Just listening to the last question just had me think a little bit about, and this case is a little bit different, but somewhat on point. But Ahmaud Arbery down in Georgia, if I'm not mistaken, I believe, wasn't the prosecutor, the local prosecutor who had a relationship with some of the people, I think one of the gentlemen who murdered Ahmaud Arbery, they had a relationship because he was a part of law enforcement, correct?
Yes.
And this state's attorney improperly, essentially didn't do her job, correct? And she's being prosecuted.
Yeah. I mean,
Okay.
I don't want to make a judgment.
You don't need to say a thing.
Yeah.
Thank you.
I think you got it.
All right, well, I have one question after all that. It's, geez. All right, yeah, I know, look, I want to just give you that because, Ms. Mulhauser actually is the one in the seat doing this job every day. So there was some testimony and discussion about how your office was called 25 times or so. I think that's where that number 25 may have come from. And that there was zero response, that you were non-responsive and that you were unable to handle. So could you just, expound on that? Can you just give some background on what that was all about?
Sure, and in order to not be oblique,
Sure.
my understanding is that there was a letter from Harford County saying that they have called our office 25 times and that we have not responded. So Harford County has taken an interpretation of the language of the bill that does not match the actual language of the bill. So the bill says officer-involved fatalities. If you look at the letter from Harford County, they say that they call our office every time, I believe it's something like an officer is present when someone passes away. So we've had about 25 calls from Harford County that are typically an individual dies of an overdose and an officer performs CPR, and then they call our office and say, we have had an officer-involved fatality, could you please respond? And in our interpretation of the statute, and I believe this legislature's interpretation of the statute, CPR after an overdose is not an officer-involved fatality, and I don't believe that it's appropriate for us to respond in that case. So in that case, those cases we have not responded. Obviously, if there was something that fell within our parameters, and we have put out protocols so that all the law enforcement agencies know what we believe qualifies, then of course we would respond.
Thank you for that clarification. That'll be good for the record. Okay. With that, that'll conclude the testimony for the sponsor panel. Thank you both very much. And we'll move on to Ms. Hilliard. And then we'll switch to the opposition panel.
Good afternoon. Thank you, Senator Smith, for introducing this bill. Elizabeth Hilliard with the Maryland Office of the Public Defender. Because it has already been there has been so much discussion, and I think fruitful discussion, I will just say that the Maryland Office of the Public Defender strongly urges a favorable report with the two amendments that Senator Smith mentioned during his introduction of the bill, because Maryland took huge strides towards historic police reform last year. And you're hearing from the experts who, as they mentioned, were granted the authority and imbued with the authority to do the investigations, that they need assistance, they need tweaking, and they need just a little bit more authority to accomplish the intent of the reform that was passed last year. We think that it is critical for them to have the tools and the capabilities to complete investigations, to take the steps that they need to take, provide subpoena power when they need it, and to prosecute when necessary. Because you guys have already listened to, I think, the experts provide all the information you need, or maybe not. I'm happy to answer questions. We urge a favorable report with the amendments that Senator Smith proposed.
I was going to say you awoke a sleeping giant, but he was always plugged in. Senator Casserly, there you go.
Can I just ask, with the Office of the Public Defender, would they support an amendment that just lets the Attorney General also prosecute all murder cases, whether it's police involved or not, that just turn over prosecution of murder cases to the Office of the, we could just beef up their salary. Would you support that amendment?
Beef up who's, I'm.
The Attorney General's office to make him the lead prosecutor in all murder cases.
Sure. I feel like I am not equipped to respond to that. That's probably a question for the public defender, but I can say that I think this is distinguishable from other murder cases. I'm sorry, let me be clear. I realize I'm
We'll
sort
call
of using
shootings,
pronouns.
to be fair.
An officer-involved shooting is different from other murder incidences in that it does involve someone with the authority of the county, the municipality, their employer behind them. And so there is a unique requirement for transparency. And I know, Senator Casserly, you mentioned recently, a few hours ago, I think at this point, but recently the uptick in crime and the uptick in murders. And I'm a very, very proud resident of Baltimore City. I love my city, and I am also very concerned with the uptick in violent crime. I think that trust in the police departments and trust in police officers and trust in the transparency and efficacy with which we investigate any potential officer-involved shooting will only work to further improve and build greater trust and community sort of community involvement with the police. And so I think that those unique circumstances, those unique power dynamics that are at play necessitate the involvement of the Attorney General's office in officer-involved fatalities in a way that would not be implicated in other cases.
Look, let's face it, in your jurisdiction, any Baltimore City police officer would have to support this bill because otherwise he'd be ruled by an incompetent prosecutor who sees nothing as a greater glory than to go after cops. So in your jurisdiction, this makes absolute sense. But in other jurisdictions in the states, people want to be able to make sure that the decision to prosecute their police officers reflects the folks who have to live with the results. And if you become prosecutor happy in a jurisdiction, you get when you have a jurisdiction that goes anti-cop on us, what happens is it becomes violent like Baltimore City. And most of our jurisdictions don't want to become violent like Baltimore City, and we don't want we don't want a cop prosecutor, a prone prosecutor, who will take our jurisdictions into the same hellhole that your cop prosecutor has taken Baltimore City. And that's what this bill comes down to, is we don't want to follow Baltimore City, and Baltimore City continues to set the standards in this state and it's the wrong person to set the standards because they're killing Baltimore City, and now they want to destroy the rest of the state. And that's the problem. It's the problem. Thank you.
Okay. I think I will just briefly, respectfully say that the political implications that you're addressing in your questions are still something that the Attorney General's office is going to be subject to because they are still an organization that is beholden to the public. They are still an organization that is transparent. You heard testimony talking about releasing the publication of their findings and their investigation. And so, and you also heard that within the last 5 months, I guess we're in March, so October to now, they're investigating 12 instances and have only produced one report, and that they're working to, as soon as there is a prosecution decision in that report, publish it. So it sounds to me like the Attorney General's office is not in any way seeking a political leaning one way or another, but rather an independent and thorough investigation. Further questions? No, thank you.
Thank you very much. All right, let's switch to the opposition panel. We'll have Mr. Culver, Mike Davey, Stephen Kroll here. There you go, come on up. And Mr. Lewis. Mike Lewis. Mr. Potashnik, you'll be in the next panel. If you want to, if there's room, you can come on up.
Mr. Chair, members of the committee, good afternoon. My name is Alan Culver. I'm the State's Attorney for Carroll County. I'm here this afternoon to speak in opposition to Senate Bill 896. This bill, with all due respect, is not necessary. It mandates certain actions that are already occurring and attempts to mandate other actions that can't be mandated. The legislature should not attempt to force law enforcement agencies to turn over evidence in one of their investigations to another investigative unit. Whether it's a police-involved incident or not, independent law enforcement agencies should and will act in accordance with what is in the best interest of their investigation that they are conducting. In certain circumstances, such as forensic analysis, law enforcement agencies need to retain evidence to ensure the reliability and the eligibility of that evidence for analysis. In Senate Bill 896, there is a clause that indicates that law enforcement agencies may not engage in activities that impede or interfere with the investigation of a police-involved incident. Once again, this is an action that cannot be legislated. If an independent law enforcement agency is conducting their own investigation in a separate crime into possible serious criminal activity, that agency is going to take what necessary actions it believes are necessary to conduct and complete a thorough investigation. Senate Bill 896 goes on to state that after the Attorney General completes an investigation, it shall transmit a report with detailed findings and a determination as to whether the Attorney General's office recommends prosecution. Once again, these requirements are irrelevant. Each state's attorney's office is an independent body that has a duty to review all information related to an investigation and make an unbiased, independent determination of what action is appropriate. We as prosecutors would not be doing our job if we did not do an independent review of the investigation and make our own determination of whether or not to prosecute. And therefore, I join the Maryland States Attorneys Association in requesting that the committee give Senate Bill 896 an unfavorable report. And I'll be happy to take questions or turn it over to the next speaker.
Chairman, members of the committee, good afternoon. Good to see everyone again. My name is Stephen Kroll. I'm the Executive Director of the Maryland States Attorneys Association and the State's Attorney Coordinator for Maryland. I've been prosecuting cases since 1984. I would like to comment on the amendments, but I did not receive from either the Attorney General's office or the Public Defender's office a copy of those amendments. We do our meetings on Mondays. Had I gotten them ahead of time, we could have reviewed them and given you our opinion on those amendments at that time. We did not receive them. I want to put out one thing to this committee. This Attorney General came forward and said he's not asking for this. We, the elected state's attorneys of Maryland, are asking for it. We want to do these cases. We are the elected. Most of the public doesn't know who the Attorney General is, but they know who their local prosecutor is, and they have faith in that prosecutor in doing the cases the right way. He said, well, I'm not asking for them. Well, maybe I am. We want these cases, and we want them to stay with us. Back in 2020, Mr. Chairman, you headed a subcommittee, as well as, at that time, Vice Chair Atterbury in the House, to deal with Senate Bill 600. These were issues concerning law enforcement. Delegate Atterbury, Subcommittee Chair Atterbury, and the Assistant Chair, at that time, to Judiciary Committee, held a hearing. That subcommittee did not recommend, I repeat, did not recommend that the Attorney General prosecute the cases, only investigate. They did not recommend that. It was not part of their recommendations, and therefore was not made law at that time. It is working, meaning the law. Everyone has said this. If it isn't broken, don't change it. We're doing the right thing the right way. We are cooperating, with the exception, of course, amendments, but I digress. But my point being is, it's doing well. The Attorney General told us that. Prosecutors have told us that. We're doing the right thing. Let us do our job effectively. How many bills could have Prince George's County and Caroline County agreeing on the same law? This one does. I want to finally call your attention to page 4, where it says, Mr. Chair, I'll be very quick, indicates whether the Attorney General recommends prosecution. The Attorney General, on my recommendation, said don't do that because it is discoverable material. If it's a recommendation for the Attorney General, we as prosecutors have to turn it over, and it's discoverable. First witness for the defense, the Attorney General. That cannot be in this bill. And for all those reasons, the Maryland States Attorneys Association recommends an unfavorable report as the Senate Bill 896, and I'm happy to answer questions. Thank you.
Well, the amendment will at least address one of your concerns, so, because it will take that section out.
Thank you.
All right. Thank you very much.
Good afternoon. Michael Davey, I'm General Counsel to the Maryland State FOP and many of the local FOPs or Fraternal Order of Police organizations throughout the state. The Fraternal Order of Police oppose Senate Bill 896 as written. As we've stated, Senate Bill 600 gave the authority for the Attorney General to form this independent investigative unit. There have been 12 cases. I've been actively involved in 9 of them as I'm representing the officers involved from the time the incident occurs until where we are right now. It wasn't until the testimony today that I even found out that one of those 12 was actually even completed, that one being in Wicomico County. This bill is premature. It's not ripe to be heard at this point. There have been no issues so far. The Attorney General and Ms. Mulhauser herself said there have been no issues so far on how these investigations have gone. They're requesting injunctive relief in this bill for nothing. They've said every department they've dealt with so far has cooperated and been involved, and there have been no issues. So why there's a need for injunctive relief at this point, I'm not really sure. But one of the bigger concerns is Senate Bill 896 would give the Attorney General's office the authority to prosecute a law enforcement officer in any case where I believe the first bill was if the prosecutor, the state's attorney refused, but I don't really know based on that amendment where we are now. The authority to prosecute police officers simply should rely on the elected state's attorney, on the local jurisdiction. The citizens of the local jurisdiction elected the state's attorney to make important decisions in and when, how they prosecute cases, and the prosecution of law enforcement officers should not be treated any differently. As I've already stated, not one agency has not cooperated with the unit. There's only been one case completed, and there's at no time has been one state's attorney who has declined to prosecute a recommendation from the Attorney General's office. With that, I'd stand for any questions.
Thank you very much. I'll give you a look. So obviously that was put in to address a specific instance, and you'll hear more about that coming up here, I suspect, for some of the witnesses that are on the list. But I can furnish you with a letter, kind of back and forth, where there's some discrepancy of where the lines are drawn with respect to how the local jurisdictions are going to cooperate with the IAD. So most jurisdictions, it's been pretty seamless. There's at least been one. There's been a lot of controversy.
But I don't believe there's been an incident to really resolve how it was going to play out. So, I mean, we're kind of...
Yeah, I mean, if you engaging private counsel, flicking letters back and forth. So, yeah, I think this will clarify that.
Thank you.
All right.
Good afternoon, Mr. Chairman, members of the committee. My name is Gavin Potashnik. I'm actually here on behalf of the Harford County State's Attorney's Office, not the MSAA, even though we echo the sentiments of the MSAA in opposition to this bill. You know, I wish I had seen the amendments as well, because that written testimony that I spent so much time on is now pretty much obsolete, most of it. However, parts of it are not. Specifically, and this really is the chief complaint that we've had, is that in the 5 months or 6 months of operation of the IID, there really hasn't been a whole lot of communication with my office about different procedures and protocols which kind of address some of the concerns that we have. Chief of our biggest concerns is that not all police-involved deaths are the same. Sometimes there are multiple suspects. Sometimes you have multiple suspects firing upon the officer fires back. Sometimes it's very messy. So what and this has never been answered, and I wish that Chief Mulhauser was here so I could address this, because we've tried to engage with her with these, and we've gotten a handful of responses that don't make a whole lot of sense in terms of policy and procedure, is we don't know who goes first. So is the officer investigated for the shooting? Do we wait for that to conclude? Do we wait until the charge the people who actually shot at the officer? We don't know. There's different permutations that have not been worked out. And as this is really the point here, is that this is premature. In the 6 months that this has happened, there hasn't been sufficient discussion to try to ferret out all the issues that we've had. And yes, there's been some grumblings back and forth, but those could be worked out. But instead of actually coming to us and saying, hey, can we work this out? How do we do this? And sit down with us, which they have yet to do, they go straight to the legislature and want to fix these problems. That's really our complaint here. It's premature, wait for things to go out, aside from the fact that it's a little insulting that they want to supplant the state's attorney who's been elected by 260,000 residents of Harford County for another entity. If that investigation is sent to us, we also want to be able to investigate on our own to make sure that that investigation has been conducted in accordance with the standards that we have set up for police-involved shootings, which nobody has asked us how we do that. So with that, Mr. Chair, members of the committee, the Harford County State's Attorney's Office would ask for an unfavorable report with respect to this legislation.
Good afternoon, Mr. Chair, distinguished members of the committee. My name is Mike Lewis. I'm a 37-year law enforcement veteran, 22 years as a Maryland State Trooper, and I'm currently running for my 5th consecutive 4-year term as Sheriff of Wycomico County. I'm also the current president of the Maryland Sheriff's Association. We are opposed to Senate Bill 896, both the Maryland Chiefs of Police Association and the Maryland Sheriff's Association. This bill would, A, greatly expand the category of newly enacted notifications required to be made to the Attorney General to include all police-involved incidents where civilian injuries likely result in death. B, it also removes primary investigative jurisdiction from local law enforcement agencies. And C, requires the physical transfer of evidence from pending police criminal investigations to the Attorney General. And D, authorize the Attorney General to obtain virtually unrestricted injunctive relief without factual justification in all incidents involving a police officer that result in a civilian death or injuries likely to result in a death. As originally created by the legislative effective October 1st, 2021, the AG's Independent Investigation Division investigates all alleged or potential police-involved deaths of civilians. After investigation, the IID sends its report containing detailed findings and analysis to the state's attorney of the county with jurisdiction over that particular incident. The IID does not decide whether to prosecute an involved officer and does not bring criminal charges. Rather, the local state's attorney retains their customary prosecutorial authority and accountability to their citizens who elected them. Criminal procedure changes proposed by SB 896 have the potential to complicate and interfere with orderly local criminal investigations and prosecutions, loss of chain of custody of essential evidence, and result in the disruption of critical enforcement activities against serious criminal perpetrators. For these reasons, the Maryland Chief Police Association and the Maryland Sheriff's Association oppose Senate Bill 896, and we urge an unfavorable report. And of course, I'm certainly available for any questions.
I have a question for Mr. Culver, Mr. Potashnik. They can take turns on responding to it. Because you brought up an issue that just me being a non-cop and a non-prosecutor kind of totally eluded me. I was listening to the Attorney General's folks' testimony. You sort of have this vision that this is a world where a cop just comes out and shoots somebody. There's nothing else involved. There's a victim and a cop, and the cop shot him and he's dead or dying, and so we got to go investigate that. But then I thought back when you all are testifying in my own jurisdiction, I'm thinking about the police-involved shootings. Both of them were sort of mass shootings, and you had thousands of witnesses, or at least hundreds, scores of witnesses in the other, and it was shooting both ways, intense shooting both ways, not ran. And so you had so now the state's attorneys, the police are rolling in. They're investigating, I guess, really two things. They're investigating, did the cop do wrong, but also what happened with, they've got to prosecute a shooter who may or may not be dead, who may just be wounded. So if you're going to hold up one you either hold up the whole investigation or nothing. And I'm thinking in my jurisdiction, when each of those happened, you rolled out with the on-scene crime team was there within minutes, and you had deployed probably 100 officers in each case from multiple jurisdictions, but totally saturated it. You had people around, particularly the one that was out at the shopping center, where people were just kind of disappearing. You had to grab witnesses, you know, if they're witnesses. You had to grab people, identify them. What'd you see? What'd you see? Nothing. Okay, goodbye. What'd you hear? Nothing. Goodbye. You heard something. You saw something. So the situations, every second, it seems like you're losing, evidence is flitting away. So I'm trying to, you listen to the Attorney General's witnesses, Ms. Mulhauser's testimony about how this works. Just evaluate that for me, would you?
Sure, Senator Castley, and that's what I was speaking to when I mentioned in my testimony the clause where the local law enforcement shall turn over evidence in one of their investigations to another investigative unit. I was thinking of the example of, similar to yours, you have, say, a suspect who goes into a bank or a convenience store and shoots a clerk or somebody in the store. Police then roll up, they shoot that suspect. That suspect's firearm is now evidence in 2 different investigations. So for this statute to then allocate that firearm goes directly to the Attorney General's office, that impedes the local law enforcement investigation. And local law enforcement, they have policies and procedures in terms of their chain of custody as to what evidence can be analyzed. They need a certified, documented chain of custody that their lab can rely on. So then what's happening when it goes into the custody of Attorney General's office? Now, certainly, they're using the State Police Crime Lab in Carroll County. We mostly use the State Police Crime Lab. So it might be the kind of thing where they can cooperate and they can work together. But that was kind of my point, is that we're trying to legislate cooperation. I mean, realistically, you need the Attorney General's office, the Maryland State Police, and the local law enforcement to work together with the local state's attorney's office. Everybody needs to collaborate, get in a room together and say, okay, we have this evidence. Let's talk about it together. Let's figure out how everybody can utilize this evidence for their investigations. I don't think it's something that should be legislated. Now, let me say this. I know the Attorney General's office uses the Maryland State Police Homicide Division. I have the utmost respect for the Maryland State Police Homicide Division. They've investigated countless homicides in Carroll County. They do a great job. But my concern is that you are dictating who keeps track of the evidence. I think that's something that has to be worked out on a case-by-case basis. So I kind of echo your point that there are concerns when you try and dictate who gets to take certain evidence and who takes care of the protocols.
Maybe, Mr. Pataska, you could hit us, you got like the Clorox shooting and you guys had some mass shootings. Maybe you can kind of relate to how this works in that context.
Yeah, and I think what you're saying is one of our complaints has never been answered, never been worked out, and some of the, one of the things that Mr. Culver indicated, which is completely true, is that when trying to legislate cooperation, you're trying to fit all the different permutations of investigations into one kind of round hole, which doesn't really hold water. I mean, in our county, and Senator, you know this, when a murder happens, we immediately assign a highly experienced homicide prosecutor in any death. And that prosecutor works directly with law enforcement. Evidence is captured, it is sustained, there's legal ramifications, talk to this guy, do this warrant, do these things, and you build a case. That rapport takes a long time. That rapport takes years to build, and our county's been successful in doing that, whether it's a police-involved shooting or not. So when you have instances where you have a messy situation, lots of shell casings, you have lots of cameras, you have, as Mr. Carpenter, you indicated, hundreds of witnesses, you've got 911 calls, all these things, that has to be captured and preserved immediately. We don't just wait for another entity to come in. We have suspects running around, Lord knows what they're doing. There's a lot of confusion as to how that is meted out. So even if the IID comes in and says, okay, we're going to investigate just the shooting, but you get everything else, Mr. Potashnik, then do I wait until they're done with that prosecution? I have to, because that witness is compromised. Do I wait for them to be done with their evidence before chain of custody is transferred to us? That has certain problems to it in building the case. It interrupts the flow of how we've been able to successfully evaluate these cases. So it's not so clear cut. And I think that the sentiment of this legislation is really built upon one premise, which is the lone officer in the middle of no place shoots somebody, and there's a certain piece of evidence that's just there. when you have most police-involved shootings that we've been involved with in our, in our county, there's a lot of different things going on. And I worry that the citizens of Harford County won't get the full adequate representation in order to make sure that these cases are evaluated and these cases are prosecuted in accordance with, what we have developed. Thank you.
Thank you, Mr. Chair. Mr. Potashnik, you were here when the Attorney General was here, and he defended this bill on the grounds of independence. His main argument was that the Attorney General of Maryland is independent, and the people of Maryland therefore can rely on his independent judgment. And without saying so, he was saying your office is not independent. The state's attorney's office in Harford County or Carroll County or Baltimore County or Wycomico County doesn't have that level of independence which it can command the respect of the public. How do you respond to that?
I mean, clearly we would disagree. It's a tad insulting to just label all of us prosecutors in individual counties as individuals who would not do right by the evidence in these particular cases. And I get that there is national best practices and standards, but so far I have not in my time in any office that I have worked in, and I've worked in Baltimore City and in Harford County, seen anybody favor law enforcement in a police-involved shooting just because they're law enforcement. I think that is kind of a sentiment that really wounds me somewhat, only because it essentially says I can't be independent in any prosecution where a police is involved. What about prosecutions involving police who do other things? Are we not independent in that as well? What about prosecutions of officers who are involved with a theft or involved with a rape or involved in things like that? I've been directly involved in those prosecutions, and the evaluation of evidence in all those cases, in fact, any case, is paramount. Again, there has not yet been the development of cooperation necessary to meet all that out, and I worry that simply supplanting the judgment of another statewide elected official for the local prosecutor who has the backing of the local people who have done that I think it's setting a bad precedent.
Thank you.
Excellent, thank you much. Seeing no further questions from the committee, thank you all very much.
Thank you, sir.
We have two more witnesses. We have Sheriff Gaylor and Jack Simpson.
Good afternoon, Mr. Chairman, Vice Chair, members of the committee. Thank you for your time. I think in large part we're probably here because we've heard it's one jurisdiction. It is Harford County, if anyone wasn't familiar with that, where I have a difference of opinion with the Attorney General in following the statute as it was passed last year. And we've had some correspondence and the conversation was had. We did have one meeting with the Attorney General and members of his staff where some things were discussed, and I think some common ground was found. There was offers for other meetings that weren't entertained. But again, last year, when Senate Bill 600 and in the preceding years, when these independent investigation bills began, I was supportive of the concept, and I remain supportive in the interest of transparency for our citizens today, that it's exactly, I supported the bill last year, but with some amendments I thought would have made the language more clear, but supported the concept and supported the bill for the independent investigations. And what passed, I think, was actually a workable bill. My problem is with the Attorney General's protocols, many of which he is trying to solidify in statute now, because I think he realizes the bill fell short of what this thing grew into. And what it grew into is going to be another police department in the state of Maryland within the Attorney General's office. The bill specifically called for, or what it passed, was that the AG had the ability to conduct an independent investigation of the cases we discussed where death or potential death was police-related. And to do that, members of his office, assisted by one or more, I think it was two or more members of the state police, which are detailed to his office, and he may employ civilian employees as needed to conduct those investigations, something that was obviously intended to be small scale, more, and I equate it related to a Department of Justice oversight investigation, where the investigation is done by the local police department with jurisdiction, and if there's a DOJ civil rights complaint, the DOJ comes in and reviews everything that's done, all the evidence, all the witness statements, conducts any other investigation they feel necessary. And that's where you get that independent, separate investigation in those cases. And to the testimony I gave in the last few years, that is what I believe passed out of both the House and the Senate last year and was signed into law. Again, the AG's protocols lift this to the creation of a new police department in our state, where in reality right now, and we've seen it in those, I think he said 12 cases, that they've not only detailed 2 or more members of the state police, they've detailed the entire department. And it's actually the state police that are conducting these independent investigations. The homicide unit, the crash team, barrack troopers, communications section, and civilians who were specifically excluded from being included as part of the investigation. So with that, I oppose this bill. I will say in the correspondence back and forth with the Attorney General, I've made it very clear, we will cooperate. I knock on wood that we don't have one of these. I pray, been through this before. I pray that in my time as sheriff and for the next 100 years, we never see a police officer take a life or lose a life in my county. But if that's the case, then my citizens, as much as we've heard on the state's attorney's front, my citizens have twice, and I hopefully a third time, have placed me in this position. They put their trust in me as their elected sheriff, as they have the elected state's attorney, to conduct the investigation, and that there are ways, and I said again, the DOJ is a prime example of how these can be conducted fairly. And I would like to offer that in the one example that was given, the law last year that passed was very specific that the Attorney General only has the authority to look at the actions of the officer and any actions of that officer as it relates to misconduct that result or that are uncovered during the investigation. In the example that was given, the shooting of the officer still requires a local investigation. It currently is what's written in statute. It doesn't have to be a competing. It can be one investigation, again, with the Attorney General coming in as this current SB 600 allowed for the AG coming in and conducting their, I don't want to say more or less an oversight, but a review to make sure there's no nefarious activities. SB 600 accomplished its job. I would recommend some tweaking to that. I know we've been here a long time. I'll just leave it at that and take questions. Oh, sorry.
I'll wait. Go ahead.
No, he said.
Mr. Chairman, distinguished members of the committee, my name is Jack Simpson. I've been a police officer for 38 years, 28 years with the Maryland State Police, retiring as a major, 2 years with the Vehicle Theft Prevention Council, and then almost 8 years with the Harford County Sheriff's Office. I've done this a long time. I've been involved in a lot of these over the years. And I know we've talked about a lot of stuff, and we've hashed out a lot of things, and I don't know if we've really gotten to where we need to go. But nowhere in the law does it say the IAU is the only investigative body in these matters. Nowhere. I'm going to conduct an independent internal investigation. At the same time, they're doing their investigation. In addition, I have a criminal component of the Sheriff's Office that I would like to detail and would be detailed within minutes of any of these incidents. In fact, you know, if that was the case, that they were the only investigative body, which I do not believe was the initial intent, the legislature has in effect created another opportunity to dim the light of transparency. Worse would be to incorporate, as the bill before us calls for, investigation and prosecution into a single body. One body from beginning to end. There's no transparency in that. In effect, erasing any hope of meaningful police reform and putting accountability in question. I'd like to lay out, again, a lot of things that I was going to talk about have been talked about. I'd like to lay out one case that occurred to us. It was a death, cardiac arrest, an elderly female, went down. Deputy happened to be close, heard the radio traffic, responded, started CPR, used AED. No efforts worked. The lady was pronounced dead. We called the Maryland State Police, as we were told in our protocols, which I don't necessarily agree with the protocols being written the way they are outside of the bounds of the law. We waited an hour for the response back from the state police to tell us that they finally contacted the IAU. IAU has now said that they will not respond. And if in fact they were going to respond, that was going to be another hour or two for a response. The family wanted the property back. The family wanted their deceased back. They wanted to make moves. They wanted to take care of the body. We weren't going to be able to do that, and that's what we're dealing with, and that's what I think some of the other sheriffs and chiefs will tell you, that it's taken a long time for these entities to arrive on scene. And then I'd like to add another little thing. You know, they're going to respond lights and siren. Well, the law doesn't require that. The law doesn't allow that. So by the time he gets there, or the trooper gets there, or the IOU investigator gets there, they've already, based on the other laws that have been passed, committed serious misconduct. So do we use an investigator that responded lights and siren to a scene in the investigation when they could potentially be subject to an internal investigation for misconduct for using the lights and siren? There's just a lot that needs to be worked out with this, and I think we ought to do it amongst us and not using the legislature.
Just briefly for Sheriff Gaylor, I hadn't thought about the Department of Justice investigations, and you have been personally involved with DOJ coming down and involved in investigations?
No, I'm very pleased to say, no, we have not been.
Okay.
But from
are
the
you familiar with the
outside,
process?
again, you heard the major's amount of time. I've been doing this 37 or 38 years as well, but familiar with, that it's not, they're not on scene immediately to begin the investigation, to take the evidence, to hold the witnesses there, to let a deceased body sit for an hour with the family and not move anything because we were waiting to see whether we're allowed to. That it's more of a administrative review, again, to make sure that what needed to be done, what was done. We heard Ahmaud Arbery case mentioned during this hearing. They didn't need an IOU ultimately to figure out that what was done in that case was criminally wrong. There was a little wheel and deal behind the scene, and that prosecutor decided not to press charges. The system works, and I believe SB 600 added that extra level by having a review, a small scale that doesn't cost the taxpayers of Maryland $5 million for the creation of a new police department, to have that review, to have that oversight or access to the investigation to ensure that nothing nefarious is being conducted. You said it earlier, I believe, sir, that all the experts, our great investigators, work around this state. Not to both Major Simpson and I come out of state police. I would put my investigators, man for man, woman for woman, a step above the state police. We don't cut corners on training. We don't cut corners on development of our personnel. And I know the challenges associated with the state police.
Okay. And I mean, is that because your people are investigating homicides constantly that versus?
No, I'm also thankful that we haven't had many. In fact,
or just serious incidents. They're constantly doing investigations versus.
They're all the time. And again, our budget is much more conducive. I lived in the state police for 28 years, retiring as a captain. Our budget, we do not try to save, not that we're not physically responsible, but we don't cut corners on developing our personnel to ensure that we offer the greatest asset to the citizens in the form of the investigative ability of our detectives.
I guess, I mean, is that explicable to some extent by the fact state police can always just say, hey, the county's got this. I don't need to have this latest stuff because the county will come in.
Well, I think they put out a very good detective. But again, having lived that life for years, and Major Simpson was assigned to the criminal section, a big part of his career, and this is not to diminish them, it's just to compliment the men and women of the Harford County Sheriff's Office and many other agencies across the state. They don't have the ability or the budget to train to the level that we do, to educate. And obviously, Baltimore City sees a lot more of the serious cases, and their investigators are probably a lot more experienced than mine. But our closure rate is probably better than most jurisdictions around the state.
Thank you.
All right, seeing no further questions, that'll be it. Thank you very much. Thank you all. All right, and with that, that'll conclude the testimony for Senate Bill 896. Before we move on to Senate Bill 763, which is Senator Sidnor, I was going to say, look, we got to do better in this committee. There are 24 jurisdictions in the state, 7 of which are represented in this committee. Each jurisdiction has its unique challenges, and if we were going to operate as one committee and one Senate in order to solve the problems throughout all 24 jurisdictions, we've got to be respectful of each other and of each other's districts. So let's just remember to maintain civility. All right, Senator Sidnor, you're up with Senate Bill 763. I know the judiciary has been here for a long time, and thank you for your patience. And
If I can, is Ms. Soth there? All right, I'll begin, and thank you very much for that. Senate Bill 763 was a bill that's been a couple years in the making. I'd initially had a bill that I'd introduced last year, which put a lot more onus on state's attorneys to collect a variety of information and report out to us, similar in the vein of what one may see done by Baltimore City's state's attorney's office. Back in 2019, the state of Connecticut did something similar. It had its legislature, it had its courts, and all other interested parties worked together and passed a comprehensive bill called an Act Increasing Fairness and Transparency in the Criminal Justice System. This bill is intended to do something similar, where we're reporting out arrest and sentencing data. One might be surprised when you're talking about what happens in our in our court systems. We've focused a lot on police officers making arrests. Our governor's focused a lot on the courts making the decisions or handing down the sentencing, but there's not a lot of information out and available about what our prosecutors are doing. There are statistics that say that 95% of all of criminal cases are pled. So you're talking about a lot of power and decision-making happening within that prosecutors, within their discretion. So this bill, as I said, it kind of gets at a lot of that information so we can take a look under the hood, see what's happening within our criminal justice system. We're looking at pleas that people are taking. We're looking at what kind of disposition and things that are being offered by our state's attorneys. I will tell you that I believe it was last fall, I was contacted by a constituent because of something that she was upset about. And upon further investigation and kind of looking into the matter, if I may recite, this particular constituent, her son was murdered back in 2019. He was an aspiring rapper. He went to someone's home to, I guess, from what I understand the facts to be, to record a song. The person's home that he went to record this song at happened to be a drug dealer. This particular drug dealer had a prearranged drug transaction that was going to happen, unbeknownst to my constituent's son. When the buyers of the drugs came into the house, they attempted to rob the drug dealer, who happened to be the homeowner. Ultimately, my constituent's son was murdered. Our county state's attorney ended up prosecuting, I believe it was 5 young men for her son's murder. So that sounds good, sounds like the prosecutor's office has done their job. However, my constituent was concerned because while everyone that was involved in the robbery side of this drug transaction was prosecuted, nothing happened to the man who was the drug dealer. So she was upset because and this is in her eyes, she saw that everyone that was prosecuted for her son's murder were young black men, but the drug dealer who was not prosecuted was not. It was a young white man. And she felt that he had just as much to do with her son's murder as these young black men. But the state's attorneys, they used their discretion, and they did not prosecute the drug dealer. So again, this legislation attempts to begin to look at and unwrap and put data forth so that we can kind of understand what's going on in our offices. So what it does, it has the state's attorneys reporting certain information to the courts, and the courts then ultimately reporting information to the Maryland Sentencing Commission. And I mean, that's generally the nexus of the bill. So I mean, I'll stop there if there are any questions.
All right, seeing no questions, thank you very much. We'll go to your sponsor panel. We'll go with, is Mona Sayoff here from Bureau? There you are. And then Latrina Antoine and Rebecca Snyder.
Hi, just start?
Yes, please, thank you.
Okay,
Welcome.
thanks. Good afternoon. My name is Mona Sahaf. I'm a Maryland resident and work at the Vera Institute of Justice as Deputy Director of the Reshaping Prosecution Program. My program helps prosecutors shrink their criminal legal system, promote racial equity, and increase transparency and accountability of the communities they serve. Before joining Vera, I worked for 12 years as a federal prosecutor in Washington, D.C. Prosecutors wield great power to shape criminal cases, including collecting evidence through subpoenas and search warrants, choosing who to investigate or charge, deciding what charges to bring, and making plea offers. Many of these decisions, especially around declination, charging, and plea bargaining, are virtually unreviewable by any court or other entity and totally discretionary to prosecutors. Despite this immense power, the general public does not receive much, if any, information about how prosecutors make these choices, which are often life-altering for people and their families. This bill is a big step towards unlocking the black box of prosecution for Maryland residents. Publicizing this data and information empowers the public to isolate and understand how prosecutors' decisions collectively and individually impact the communities that they are elected to serve, and what priorities a state's attorney is pursuing. With this data, community members will have information necessary to understand important issues like what resources the state's attorney spends on cases driven by substance abuse, how frequently they ask for pretrial detention of people who are innocent, and how their decisions contribute to racial disparities in the system. However, while this bill is a significant step towards transparency, its success will depend on helping state's attorney's office to implement it effectively. The vast majority of state's attorney's offices likely do not have the in-house capacity to properly collect or report many of the data points in the legislation. As such, the General Assembly or the governor should consider providing statewide technical assistance to help prosecutors meet the demands of the legislation. You can see my supplemental testimony for some additional data points that could be collected. Thank you very much. Happy to take any questions.
Distinguished members of the Judicial Proceedings Committee, thank you for the opportunity to testify in support of the collection and publication of criminal case and prosecutorial information bill. My name is Latrina Antoine. I'm the editor-in-chief of Baltimore Witness, a nonprofit organization that uses shoe leather reporting and data science to track homicides and non-fatal shooting cases under adjudication in the Baltimore City Circuit Court. Baltimore City is in crisis. In 2021, there were 339 homicide and 488 non-fatal shootings. There were approximately 156 investigations and 79 arrests for homicide, and 111 known suspects arrested for non-fatal shootings. Of those arrested, only 137 cases made it to adjudication. 17 of these cases were null prossed, and approximately 82 cases received a conviction. 7 defendants were released on bail, and 310 plea offers were rejected. The chronic lack of transparency in criminal justice and the woeful state of data collection and information in the city is reflected in efforts. This legislation session is calling for greater transparency for the judiciary, pretrial services, and today, the prosecution's office. We applaud the committee's efforts to address this critical transparency issue. But as the current bill moves forward, we would urge the committee to consider factors that are needed to ensure a successful bill. The legislation, regulation, data gathering systems, government agency cooperation, validation. These 4 areas will transform any governmental push into substantial aid to the community by offering different perspectives to violent crime. However, a validator of data is needed to guarantee success. As evidenced by recent data
Ms.
dump.
Antoine, if you could please put your mask back on, and then also, your time has expired, so if you could briefly conclude.
Yes. We respectfully request that the committee include in the bill external validation to ensure the integrity of official data. Thank you.
Thank you very much. All right, I think, is Ms. Snyder here? I think I just saw you come in. You're the last one up, so come on up.
Sorry, I was testing
No worries.
elsewhere.
Just in time.
Shoo. Well, thank you, committee. My name is Rebecca Snyder. I'm the Executive Director of the Maryland, Delaware, D.C. Press Association, and we urge a favorable report for Senate Bill 763. You've heard, I'm sure, from a lot of panelists. I know it's been an intense day for you all. So I would just note that many reporting depends on aggregate data. I think there's a lot of really substantive information that can come out by a consolidated bill or recording of this type. And that would allow journalists and advocates to really examine the efficacies of the programs that you're putting in place and shine light where there needs to be light and help reinforce what should happen. So I will leave it at that. We're very much in favor of this bill, and I urge a favorable report. Thank you.
Excellent. Thank you very much. All right, so that'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel, and we'll start off with Chief Judge Morsi. Ms. Harris, if you want to come.
Good afternoon, Chair Smith and members of the committee. For the record, my name is John Morsi, and I'm the Chief Judge of the District Court of Maryland. The judiciary opposes this bill, Senate Bill 763. The bill requires the judiciary to work in conjunction with the state's attorney's office and the Sentencing Commission to track and report 75 individual data points on every charge of a crime, whether initiated by a ticket, by a complaint, or other charging document. In the district court alone, this bill would apply to almost 130,000 criminal cases, almost 300,000 must-appear traffic cases, and more than 750,000 traffic citations. That's over 75 million data points a year. Not to mention the fact that it would require the courts to coordinate with 24 separate state's attorney's offices, and that some of the required data would be impermissible for the court to maintain. Things like whether a plea was rejected or not. We wouldn't know that and really shouldn't know that. There's a very real operational, logistical, and fiscal concern over the bill. Take, for example, a traffic ticket. Individuals can plead guilty to the citation prior to coming to court. And even if they did decide to come to court to contest the case, there's typically no state's attorney in the courtroom. The data collection process in these instances, which again account for over 1 million different cases, would take more time to accumulate this data than it would actually take to adjudicate the case. Further, there's a misunderstanding of the MDEC system and its capabilities. MDEC is a case management system designed to keep and store cases as they are adjudicated, like hearing dates, notices, sending out notices of trial dates, and tracking things like the Hicks date. It's designed to optimize case management for the courts. It was not designed to be and never was intended to be a system that tracks other data. There are database systems whose function that may be that, but that's not what MDEC is. As Ms. Harris will expand upon, we need to purchase and stand up an entirely new database management system to implement this bill. I'll leave it with that. I thank you for your time. I see I'm over my time, and I want to be respectful of this committee, and I'd be happy to answer any questions. I would urge the committee to vote unfavorably on this bill. Thank you.
Good afternoon, Chair, committee members. Nice to see you again. My name is Pam Harris. I'm the State Court Administrator. Senate Bill 763 requires, among other things, that the state's attorneys in 24 jurisdictions report to my office, the Administrative Office of the Courts, as Judge Morrissey said, 75 data elements that are most of them are non-existent in our current system. We are supposed to also record this data, keep it up for 10 years, but the legislation is silent on how this data is to be captured or how to address the possible expungements during this 10-year holding period that this bill requires. This bill would require significant fiscal and operational resource impacts on the judiciary, since our case management system, as Judge Morrissey addressed, was not intended or designed to be a data warehouse for capturing information. It is a case management system for the court. We believe, given the extensive customization and development changes necessary to the core case management system, which is operated on a national basis as an off-the-shelf like Microsoft Word, if you will, that the vendor will probably not wish to leverage these changes to its core system for Maryland. Another possible approach could be the development and implementation of a web-enabled database where 24 jurisdictions feed directly into that website, but it's non-existent at the time, and it would be expensive and time-consuming to develop. Excuse me. You have our position paper, and we urge an unfavorable report due to the complexities of this legislation. Thank you.
All right, excellent. Seeing no questions from the committee, thank you very much, and thank you for your patience today.
Thank you, Mr. Chairman.
Thank you.
Members of the committee.
Oh, sorry, I'm sorry. My apologies. The sponsor of the bill, sorry, has a question. Senator Sidnor.
Thank you very much, and good afternoon.
Good afternoon, Senator.
Just because I've had conversations with the court, so I just wanted to make certain that my colleagues have some understanding. With the data that's being asked for in this bill and the data that you all collect, would you mind sharing just about how much of the data is collected by the courts versus what's being asked for?
We'd be happy to get you that.
Thank you.
All right, with that, thank you all very much. Thank you for your patience today. Thank you. All right, next we'll hear from Alan Culver, we'll do Gavin Patashnik, Karen Mitchell, Steve Kroll.
Good afternoon, Mr. Chair, members of the committee. Once again, I'm Alan Culver, State's Attorney for Carroll County. I'm here to speak in opposition to Senate Bill 763. This bill would have an enormous fiscal impact and workload impact on our budget and employees. This bill would require our office to create a database to capture the data every time there's activity in a case. Our office handled approximately 6,000 criminal cases with 15,000 court hearings in 2021. Our employees would have to review each of these 6,000 cases to input data into the various categories required by Senate Bill 763 after every one of these 15,000 hearings. The onerous task would require us to hire 2 additional staff members, an attorney and an IT staff member. The bill would require the Carroll County State's Attorney's Office to increase the budget between $770,000 and $1 million. That figure came when when it was 65 categories. I'm not sure if we have fewer categories now. One of the categories of data required under amended Senate Bill 763, approximately a number of the categories of data are already available from existing sources. MDEC, Maryland Judiciary Case Search, and the Maryland Sentencing Guidelines already collect much of the data. The Maryland Sentencing Guidelines capture the data in circuit court cases. The Maryland Judiciary Case Search is an existing tool that already exists, listing case numbers, charges, bail status, and the disposition of charges. Case search could be modified to collect the additional data that is sought by the bill. Maryland Judiciary Case Search would allow for a uniform statewide platform that would still permit comparison among jurisdictions. There is simply no compelling reason to pass the bill to collect duplicate data, especially when the overwhelming and crippling workloads and costs are considered. The Carroll County, the Carroll County State's Attorneys Association joins the Maryland State's Attorneys Association in requesting that this committee give Senate Bill 763 an unfavorable report.
Good afternoon. I am Karen Piper Mitchell. I'm the Deputy State's Attorney for Charles County. I echo the comments of my colleague, and I also speak from the impact with respect to Charles County. Like Carroll County, it would involve additional expenses. Right now, we evaluated at least $500,000. It may be more. Like was spoken, we have a case management system, but it is not designed with these individual data points. And so the first thing we would have to do, and ours is it's not a customized system. It is a system that exists in multiple jurisdictions throughout the United States. We don't know if they could customize a special database for this. We would probably have to have a standalone database that is created, and then you have the fees involved in maintaining that. Additionally, some of this information, even though it's captured by the courts, I thought it was telling that when speaking about what the AOC could do is they're talking about potentially maybe there has to be a website where this information is uploaded. Well, who would be required to do the uploading? It seems that based on where this bill is, it would be the state's attorney's office that would have to be responsible for uploading information that is already at other places. Additionally, some information we do not have. The disability of the defendant. Would we have to ask the defense, what if any disabilities do your client have? Whether or not when they were accepted for representation, well, that's done through the District Court Commissioner's Office when they file an application, and that application is accepted or not accepted, and that information is sent to the Public Defender's Office. That's within the court system's records. It is not within records that are sent to the state's attorney's office. Additionally, with respect to having to provide the information on a website, we would have to then expand our website and create a system that would also feed that information. But we do not and cannot do it with our current employee staff that we have. We would have to hire people that would be specifically designed for data collection just for the purposes of this bill. We request that you return an unfavorable on this bill.
Good afternoon, Mr. Chairman, members of the committee. I'm going to come up here with a parade of the same types of complaints as before. The cost to our office would be astronomical with respect to the implementation of this bill. And I will tell you that we just got the county to approve an increase in our budget so that we could increase our staff so we could accommodate body-worn camera. And what this bill would do is it forces us to go back to the same county council and ask for upwards of about $1.2 million to implement the data points of this bill. I appreciate what Senator Sidner is trying to do. He's trying to collect data so that they could analyze things. I appreciate what Veritas is saying. I appreciate all of that. But the way the bill is written, the 75 different data points that are being asked about is just too costly and too logistically difficult for us to gather in a manner which is in any way helpful. I think the better bet in this case is to at least put together some sort of work group and commission to, one, identify what data is being collected by different law enforcement agencies and also the judiciary, and two, what would the cost would be to aggregate that data initially before we start asking the state's attorney's offices to start aggregating data, a lot of which also maybe includes thoughts and impressions, which I think is also a dangerous road to go down. So with that, I won't take any more time. I'm here for questions, but we would ask for an unfavorable result with respect to this bill.
Mr. Chairman, members of the committee, good afternoon again. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland, Executive Director of the Maryland State's Attorney Association, in opposition to Senate Bill 763. I do appreciate what Senator Sidner is doing, and I promise him, as I always do, if he wants to call me and work with me on this bill or any other bill, I'm happy to do it. I also want to say, as far as this bill, if this committee accepts the amendments that are there, I want the court to look at the committee rather, see where I've been recently. Page 4 of 12. Where it talks about disability status, if any, and the source of disability status. We can't violate a defendant or a victim or witnesses or anybody's HIPAA rights So the public defender or the defense attorney would have that information, not us. We can't even ask that question. The district or neighborhood, number 7 of arrest, try to explain to a young prosecutor where Laurel is located. Good luck with that. And finally, the charges brought by the state's attorney. Does that mean on a district court appeal, it would be a minor traffic offense or some minor traffic district court appeal from the district court? There would be hundreds of thousands of cases, as Judge Morrissey indicated, and for all those reasons, we'd ask for an unfavorable report as to House Senate Bill 763. I'm happy to answer questions. Thank you.
Thank you, Mr. Chair. Just out of curiosity, how do you all share information about your offices with the general public?
Each office is different. There's no general of the 24 jurisdictions. Everyone does something different. Most of the people get their information, most of the jurisdictions get their information from the AOC, the Administrative Office of the Courts, from guideline sheets. When you fill out a guideline sheet, as you know, Senator Sidnor, it's a wealth of information. It's a treasure trove of knowledge and information. It's all been agreed upon by the state and defense. So most of that information is shared there. Some do internals. In other words, they keep their own statistics from there, but depending on their budget, the number of cases. In a small jurisdiction, it's relatively easy, but the larger jurisdictions, it can't be done.
I mean, because I took some time and just went through various websites that state's attorneys hold, and outside of Baltimore City, and I believe Prince George's County was beginning to work on this, not many of you offer any information to the public, so the public really doesn't know how you're going about prosecuting cases, how many people are being prosecuted, and the like, right? And then looking at information from the Sentencing Commission, that's about sentencing, but not necessarily about the plea bargaining that's happening within within the courts, right?
Well, the problem is cost, as Mr. Potashnik pointed out in the fiscal note.
Right. So
That's our problem. But I'm not saying it's not important. What I'm suggesting to you is there's a way that we try to get better information. It's just, we're lucky we've got enough people right now prosecuting cases.
right. So I know last year I withdrew the bill because the burden was placed on you all squarely. This year, after having some discussions, the onus was somewhat put onto the courts with you all supplementing information, so not necessarily duplicating anything, but supplementing things that weren't already in an MDEC. Is that your read of the bill?
My read of the bill is we got 4 people in this panel right here willing to work with you to assist you and try to help you get any information you get. We weren't consulted on it at all, but we welcome the opportunity to be a part of the conversation. I know the prosecutor.
Did you say y'all weren't consulted?
I wasn't. You and I have not. You're my friend. I haven't talked to you in a while, sadly.
That's because I had already had the emails from us going back and forth about the cost and the different systems that you all had, right?
I welcome the conversation, Senator Sidner. I do.
Okay.
I know what happened in Connecticut. I know the prosecutor there. I know what they did there. And as you mentioned in your opening comments, it was an open dialogue. And have an open dialogue is, in my opinion, where you start.
Thank you, Mr. Chair.
If the cost of the infrastructure was borne by another organization, would you still take your position to be opposed to it?
I'd have to go back to the committee and ask them that. I can't answer that question right now. I don't know.
Because it seems like, what I've always heard is that, the cost to stand up the information technology infrastructure to be able to do these things. If, for example, Do It had a centralized database and all that was required from your office was to input the data in, would you be opposed to that?
Again, I got to go back to the committee and find out what the fiscal is to each office. So to answer your question, I can't answer that right now.
Okay, thank you very much.
More of a comment to Senator Sidnor that I'm really sympathetic to any bill seeking to make data more manageable. I've looked at this many times that every piece of the state operates in these silos of excellence. Everybody collects data, juvenile services, the schools, the prisons, the prosecutors, the defense. Everybody collects data, but none of us talking. We can't draw any pictures as policymakers because it's not merged in a fashion that we can use it. I really think we need to look at a holistic, and it's going to have to start. You can't take the old data. You have to start off with, okay, here's a brand new defendant. Let's track that person and start putting them in a system. I think we need a new system. We need to look at this. Personally, I thought we ought to be bringing in things like, if we're really going to look at this holistically, we got to be able to merge their school records. I mean, did he go to a bad school? Did this start out because he had a bad school? Did it start off because he was DSS's records? Was this child abuse? Was it that DSS failed to address something when they were in commitment? I think we really got to have these whole pictures of people moving through our system. Until we do that, we're never going to really truly give the level of compassion, the level of service that we need to do to try to right some of the wrongs that people face, both the victim and the perpetrator. Because as is pointed out frequently, these people have problems, but we're not addressing them. We either put you in jail or we put you in society, but we don't correct stuff. And so I'm totally sympathetic what you're trying to get at. I think it's going to take a lot, and it needs to be a major initiative to really erase the silos and connect them all, because we just operate in silos of excellence. Thank you, Mr. Chairman.
Senator Cassidy, I only imply one thing. We have to regard people's HIPAA rights, their privacy rights. There's a lot of people that we do not want to make matters worse.
Senator Cassidy.
Through that, because if you look, there's ways to you sanitize the data. So each piece sanitize, because I don't care, a lot of with data collecting, we can sanitize it into the policymakers. So there's things you can do to make that happen if we want to. There's ways around that. So thank you.
No, actually, to Senator Cassidy's point, you bring up a really good point, because we've been having this discussion for the last couple of weeks, and we're obviously, this week, we're focused on, transparency. So today, we'll be voting on a judicial transparency bill. We worked with the judiciary, worked with the Sentencing Commission. I think we've got a pretty good product that we'll put out. But we also have another bill that takes pieces, elements of yours and the Longitudinal Data Center, and we kind of try to patch something together. So to that end, we're trying to, we're engaging some of the stakeholders in the next couple of days, and we'd love to, you'll be hearing from us, so I want to give you a kind of a reprint of what we've come up with. And
We welcome it.
Yeah.
Like I said, here's four at the table that are willing to cooperate and be part of
Absolutely.
it.
Yeah, that's great. I think it'll assuage some of the concerns that were raised today, by the way. But seeing no further questions from the committee, thank you very much. We'll hear from Mr. Sanderson. You're up next. And Crystal Williams.
Thank you,
Williams.
Mr. Chair and committee members. I'm Michael Sanderson with the Maryland Association of Counties. We've also filed opposition testimony to the bill, and I think a lot of the ground is already what you've had covered with previous testimony. So I'll say we've worked with the sponsor on a number of issues. He's been diligent in trying to weave through tricky issues and find a solution. There's a good bill on the floor that's pro-transparency. We support that. So there's a path forward here. I would just say if the conversation is pointing in the direction of trying to work something out, I think you've already seen some of the sort of channel markers for doing that. You don't want to have, in the interest of promoting transparency, step on the toes of prosecutorial discretion. That's not my bag. We're the county governments. That's not our thing. That's the panel you just heard. You also do need to make sure that you protect the guardians of the information and the information itself. You don't want to get into HIPAA violations. You don't want to get into the areas that under our PIA and so forth, you don't want to reveal to the public, and those are always trickier than they seem, particularly the burden on the custodians to make those calls. In this case, it would be employees in the state's attorney's staff and so forth. So that's important to watch out for. And third, county governments end up supporting and funding the state's attorney's office. So frequently I'll stand here and say, please read my written testimony. Today I'll say, please look at the fiscal note on this bill. Your professional staff did a good, solid 6-page walkthrough on piece by piece what would be required under the bill, and it's a slalom course to go down, in the Olympic spirit. It's a tricky one to go back and forth on what would be required to do all this. So I get the spirit of the bill. The ticket for county governments as written would be awfully big and broad. If we want to try and work something out and advance the idea, I get it. Sometimes you turn the speakers up to 11, you see who complains about the loud music. You got that today? We're concerned about the fiscal note, but we get the idea behind the bill. So if it's a work it out plan, we'd love a seat at the table, but I think the conversation's been helpful. Thank you.
Thank you, and good afternoon, Chairman and members of the committee. My name is Krista Williams, for the record, Director of the Government Relations Division for the Office of the Public Defender. I did submit an informational, but I just want to make a correction for the record that we are actually supporting this bill with amendments. I have heard the testimony of others here today. We do understand that there are some concerns with the bill. That being said, we do believe that these are easy fixes that can be worked out, and this bill can move forward. I understand that Senator Cassidy has expressed concern about other avenues to get particular data, and that is certainly important, and there are other bills that do select other data. This bill is specifically on getting prosecutorial discretion data. And so I want to just say in my statement that the transparency and integrity of Maryland's justice system is of vital importance to every citizen, and prosecutors are an integral part of that justice system. They are an extension of law enforcement. And currently, data regarding criminal and juvenile delinquency cases in Maryland are collected by different entities throughout the state of Maryland. However, none of those entities currently track prosecutorial discretion cases and decisions made by prosecutors. And one of the things that I don't think that we're taking into consideration here behind the purpose of this bill is that we do need to understand that there are implicit biases in prosecutorial decisions. As a defense attorney, I have had many a times where I'm sitting in court and you see the disparities of cases for otherwise similar defendants, similar crimes, similar backgrounds, and in fact, one particular case I remember vividly, a judge actually called out the state's attorney for very obvious disparate treatment for two defendants that were same age, same crime that they were convicted or that they were charged with. My client had an extensive history, extensive background, not only in multiple jurisdictions throughout the state of Maryland, but outside of the state of Maryland. The other individual had no background, and the state's attorney actually chose not to transfer the other client and actually chose to transfer my client, pointing to more sympathetic background, family issues. And the only difference between these individuals is their race. And I didn't say anything, but these are things that we witness as litigators, and we don't want to acknowledge, we don't want to have that conversation when we're witnessing these things. And I think it's important to have these very critical conversations that will get the information and actually put it out for us to actually discuss in a way that is productive and will actually address all the disparities in the criminal justice system. So I do support this bill, and I do look forward to the opportunity to speak with the sponsor about specific amendments that we can make this bill work. Thank you.
All right, seeing no questions from the committee, that'll conclude the testimony and the hearing for Senate Bill 763. We'll now move on to Senate Bill 864, and we'll start off with, we'll have Commissioner Harrison. We'll just start off with you and then move forward with Adam Abadir. Yep, there you go.
Greetings. Good afternoon, Chair Smith, members of the committee. For the record, my name is Adam Abadir. I serve as Deputy Director of State Affairs for the Mayor's Office of Government Relations, speaking today on behalf of the Baltimore City Administration. I'd like to thank Senator McCray for introducing Senate Bill 864 on behalf of the Baltimore City Administration, and we support this bill with amendments. So Senate Bill 864, as written, would grant a Maryland jurisdiction's police chief or the chief designee the ability to terminate the employment of a police officer at any time prior to the police officer being administratively charged if the police officer has been accused of violating an individual's constitutional rights in a manner that is egregious, shocks the conscience, or committing a crime of violence, and there is video or audio evidence of the police officer committing this act. The Mayor's Office of Government Relations has submitted written testimony that goes into more details about this bill's inspiration, but partially inspired by the actions taken by the Minneapolis Police Department, who fired then Officer Derek Chauvin one day after the video footage of the tragic death of George Floyd came to light. When confronted with the reality that should certain similar circumstances occur in Maryland, our jurisdictions would not be able to take similar actions, Senate Bill 864 was considered. And as written, Senate Bill 864 also considered opportunities for police officers terminated in these circumstances to appeal this decision, balancing due process with the public interest. Now, recognizing that there's significant interest this bill has garnered and the questions have risen around due process, the City Administration supports amendments to 864 that would authorize the Maryland Police Training and Standards Commission to study the authority of local police chiefs to immediately terminate a police officer under certain circumstances, such as those that occurred in Minneapolis, with a report being generated by the end of the year. The Baltimore City Administration looks forward to working with all parties to discuss the results of this study and believes this will lead to the best possible legislative outcome. And for these reasons, we respectfully request a favorable report on Senate Bill 864 with amendments. That's recently come to my attention that you all might not have those amendments, so we're going to work with the bill sponsor to get those to you as quickly as possible. But essentially what we're asking is this bill be changed to a study of how and what other jurisdictions currently have this power, what is the legislative framework that they operate by, and what of that can be applicable to the state of Maryland. With that, I want to bring up Police Commissioner Harrison.
Good afternoon, Mr. Chairman, members of the committee. Thank you for allowing me to speak in favor of Senate Bill 864 today. I have said publicly many times before that I strongly support a system of officer discipline that is fair, provides due process, but also empowers the head of a law enforcement agency with the ability and authority to take swift disciplinary action when an officer has demonstrated an extreme lack of respect for the sanctity of life and/or a flagrant failure to comply with law. What I'm really talking about here is an extreme circumstance such as the George Floyd situation. I know we all know the facts, but I really want to really quickly talk about the timeline of the situation. On May 25th, 2020, Minneapolis police officer Derek Chauvin kneeled on the neck of George Floyd for approximately 9 minutes. Hours after Mr. Floyd died, video footage taken by bystanders was released, sparking almost universal public outrage at Officer Chauvin's actions. Then, on the very next day, the Minneapolis police chief fired Officer Chauvin. Chief Arredondo delivered the very swift and certain consequence that the situation absolutely demanded. Maryland chiefs cannot deliver this type of justice now and still will not be able to when House Bill 670 goes into effect later this year. To be clear, HB 670 does provide for certain types of emergency discipline. For instance, a chief can suspend an officer without pay for up to 30 days if it is in the best interest of the public, and he can suspend without pay if the officer is criminally charged with a variety of crimes. An officer can only be fired once he or she is convicted of various crimes, receives PBJ for a felony, or after an administrative disciplinary process concludes, but that typically happens after the criminal case concludes. This issue is very simple to me. If you kill someone in cold blood and the heinous act is captured on video, you should be fired immediately. That said, we have to get it right. We have to ensure that there's an appropriate process for the terminated officer to seek judicial review of termination. So I'm supporting an amendment that requires the Maryland Police Training and Standards Commission to conduct a nationwide study of how other jurisdictions handle these types of situations and what type of appellate process is established for the officers. I believe studying this topic will better inform legislators, agency heads, officers, and the public as to what is most effective to provide swift and certain consequences for those who betray the trust of those they serve. And for all those reasons, I urge a favorable with the amendment report on this bill. Thank you.
Hi, Commissioner, good to see you here. So what's the difference? I mean, I think, don't we already have the power to suspend without pay?
We have the power
in
to
these
suspend
egregious cases. Isn't there already the power under the current law to suspend without pay?
In egregious cases, yes, sir.
I mean, what you describe here, these are egregious cases. I mean, you just caught somebody, what's laid out in the bill here? These look like pretty egregious cases. We're not doing this because there was a dispute or somebody used a nasty word. This is serious stuff. So we would be able to the chief would be able to suspend without pay. But what's the difference? If you suspend without pay or you terminate them, why not just, what do we get by, okay, you're technically on the force, but you're not getting paid, you don't have any police rights, and now you do your appeal. What do we get out of termination? But in this bill, I terminate you and you can fight back. Currently, I hold you on and you fight, and then I throw you out. What do we get with this?
Well, I think we're asking for a nationwide study because there are many jurisdictions where the executive of the law enforcement agency is authorized, like in all public sector jobs, to terminate a person when they commit a crime that is so egregious that is in the best interest to do it as it is done in all business, in academics, faith-based, and all the other disciplines, with the exception of police, especially when we see something with our own eyes and we know right there what the outcome is going to be when we conduct an investigation because it's right there before us to see it.
Okay. I'm just saying cameras are often mislead. You know, you see that, but you didn't see that, and you get the other testimony, and this looks really bad, but if you saw it from that angle or that angle, takes away some of it. So, again, I get back to my original question. If I can suspend you without pay, you're not getting any money, you're not in a police uniform, you can't do any policing stuff, you're over there on your own. Or I terminate you, in which case, you're not getting any pay, can't use any policing, and you're over there on your own. What do we get by saying terminated versus suspended without pay? I mean, if the current law says suspended without pay, I just trying to understand, why would we go this, what does this give us through this bill?
Well, it's been my experience that the community expectation is that we deliver the same fair and impartial discipline that is experienced in every other discipline. If that crime had been committed in any other discipline, the person would have been terminated. And
Really,
that's the expectation that citizens are asking for from their law
I
enforcement
mean, as far as I
professionals.
know, all the state employees get some due process. This says you're terminated without due process, and you fight your way back. So I'm not aware of any other state employee that would be treated like this.
That's exactly why we're asking for the study, to examine how Chief Arredondo in Minneapolis was able to effectively do it, and the many other jurisdictions and states that allow for it as well.
Okay, all right, thank you.
Thank you.
Thank you, Madam Chair. I guess I'm pursuing the same line of inquiry. So this is triggered by a policeman who allegedly violates an individual's constitutional rights. But policemen have constitutional rights of their own, and due process is one of them. So if you unilaterally terminate a policeman without according him any due process rights, aren't you committing the same constitutional violation of his rights that you're accusing him of doing with somebody else? And I append to that, it appears you're positing a video or audio evidence exception to due process. Are you aware of any court cases, federal cases, that have held that a person is not entitled to due process as long as there's video or audio evidence of the police officer committing a crime? I'm not aware of such a case. But are you aware of such a case?
I'm not aware of such a case, but I think we're all aware of the video we watched when Derek Chauvin killed George Floyd.
I absolutely agree.
So with that school of thought, in any other discipline and in any other profession, if a crime was committed here in this room, a person would be terminated immediately if they committed that crime. And so I think what communities are asking and demanding is that there's fair and equal treatment of everybody and not special treatment for any one discipline.
Are you with the, you're an attorney, right?
No,
You're not, okay. It seems to me, I'd like to see an attorney general's opinion, or some sort of an attorney's opinion, that due process doesn't govern as long as there's video or audio evidence of something bad having happened. If I can get that, then I'm comfortable with the bill. But otherwise, I'm more comfortable with Senator Cassidy's formulation that you suspend the person without pay, and then you give him his due process or her due process rights to contest that. And if that doesn't work out, then you terminate. Thanks.
Commissioner Harrison, Mr. Abadir, nice to see you again.
Nice to see you.
Seen a lot of you these days. So I also struggle with the bill, believe it or not, because of my strong belief in due process. And so I'm glad you turned it into a study. I think that's a better approach at this point. But I also kind of am concerned about how it's determined. It's still subject to some modicum of discretion. For example, you talked about Derek Chauvin, but like a situation that you're familiar with, I'm familiar with, everybody in Baltimore is familiar with, happened before your time, Tyrone West, for example. There could be, and I mean, I would have probably said or decided if I were the police commissioner that those officers acted egregiously, but nothing happened there. And then just the other day at Northeast Baltimore, I think it's still, that we still don't know. There's still an investigation, I imagine, ongoing, or maybe there's an update, I don't know, about the officers that fired into a car, ostensibly because a driver had a warrant. So how would you guard against that aspect where it's still subject to interpretation or discretion? Like, I think, and I'm not the police commissioner, but I think firing into a moving car for someone that's not an imminent threat is egregious. Do you see what I'm saying? But perhaps Commissioner Harrison or someone else does not. So how do you guard against that? Like, you're setting a bright line criteria, but it's still subject to human interpretation, right?
Well, great point. And I think we agree on that. I think that's why we're asking for it to be a study, because there are so many jurisdictions within states and so many states that see it the very same way as Minneapolis does. That's why we're asking for a study, because while Maryland may see it as due process, apparently it is very necessary and very much authorized in many other places. We want to see the effectiveness of executives being able to have the same executive authority as an executive in any other major corporation in private sector and in the public sector, where if we saw something as egregious as what we saw with Derek Chauvin, and we saw, there's been others, too many to name, it's too shocking to the conscience and it's right before our eyes. And we don't need an investigation to tell us what we're seeing right before our eyes. Sometimes it can be deceiving, but that instance, it was not. And I think we need a study to determine the effectiveness of giving chiefs who already, many across the country already have it. Why is this so different here? We want to study that.
And I'll just add that, we'll get the amendment language to you as soon as we can, but that the things that we're talking about in the study are compiling a list of what jurisdictions currently have this power, compiling a list of the enabling language that grants these powers, and then recommending some changes that could be made to state statute that would bring those powers to Maryland if it is determined that that is something that should be done.
Thank you.
Thank you.
Seeing no further questions from the committee, thank you both very much.
Thank you, sir.
And so that will conclude the testimony for the proponents of the bill. Switch to the opposition panel. So is Michael Shire here? And then Mr. Davey.
Good afternoon again. I'm Michael Davey, General Counsel to the State Fraternal Order of Police. As it pertains to Senate Bill 864, the Fraternal Order of Police would be opposed. Senate Bill 864 would give the chief the authority to terminate the employment of a law enforcement officer prior to any type of investigation, none whatsoever. If the law enforcement's been accused of violating an individual's constitutional rights in a manner that is egregious or shocks the conscience, there is no definition as to what that is when you see it. It's very subjective, it's per person, and without an investigation, you really don't get into the meat of what actually happened. Committing a crime of violence, those are all felonies in which you can be suspended without pay for already under the Police Accountability Act. There has to be video. I've watched hundreds and hundreds of body-worn cameras that sometimes what you look at doesn't look real good, but until an investigation is done, you don't get to the facts to see what actually happened. And because it doesn't look good, doesn't mean the officer did anything wrong. This bill only gives, or strike that, the chief determines the termination is in the best interest of the public or the law enforcement officer, or excuse me, the law enforcement agency. What does that mean when we have a chief who is appointed by elected officials who may go to that chief and say, hey, that video looks really bad, you need to fire that officer? And the chief's kind of in a catch-22. Do I not fire him and maybe I get fired for not doing what my boss says? Or do I fire him just under public pressure? And we do have a lot of that. The only appeal right in this case, and the only due process you get in this bill is the right to appeal if you are not criminally charged or you're not found guilty of all charges. There's nothing in the bill that says if you're found not guilty or not charged, you get your back pay or anything of that nature. Cases can go on and on for years. We have police-involved shooting cases, use of force cases, that some states' attorneys will resolve those cases in 30, 60, 90 days. We have other cases that go on for 15, 16, 17 months before the state's attorney makes a decision on whether to charge. There's no due process that relates to this case. There's no time limit in this case. There's no back pay. For those reasons, the state FOP would oppose this bill. Thank you.
Good evening. My name is Michael Shire. Thank you to the committee for your time tonight. I'm a board member with the Anne Arundel County Fraternal Order of Police. I serve as a police officer in the state with more than 18 years of experience. I'm a graduate of University of Maryland Law School and an attorney practicing Maryland in the state of Maryland. I appreciate that the sponsor would like to alter this bill into a study, and we can certainly talk about that, but I do want to point out some of the issues that are with the bill as it stands right now. The Maryland Police Accountability Act gave agencies broad authority to take disciplinary actions against its police officers, including enormous power to suspend them without pay. If it's not disturbing enough that this bill seeks to circumvent this body's own disciplinary scheme established by the MPAA and terminate a police officer on a bare accusation, then I need to remind this body that the United States Supreme Court has affirmed government employees have a due process right attendant to the property interest in their employment. You cannot constitutionally terminate a government employee on such a scarcity of evidence as this bill would permit. The bill seeks to allow agencies to put politics, public outrage, and personal feelings of a police chief above constitutional rights. It's a dangerous day when this body or any government body attacks such basic foundational constitutional rights of any person, entity, or group. The accusations of this bill speak of need not be based on very much fact or vetted or proved to any particular standard. I ask the supporters of this legislation to think where we would be if we would allow such an empty standard to allow for the deprivation of any person's liberty or property. Our constitutional democracy was created specifically to protect us from such monarchical and tyrannical acts of our own government. There's no bound to how these laws can be used to suppress or oppress the rights of righteous good people and good police officers. A video does not tell the whole story. That's why we have investigations. A snippet of video used to preemptively convict an officer can easily be used as a tool of a police chief to attack an otherwise good officer that just happens to fall outside the favor of the police chief. Again, we appreciate the amendment and we would support the analysis that it hopes to achieve, but as this bill is written, we find it extremely egregious and would recommend an unfavorable report. Thank you.
Thank you, Mr. Chair. And this is Mr. KV.
Yes, sir.
Our other witness, he said that I guess he would take the amended bill under consideration. Could you tell me what your position is about?
That, on behalf of the state FOP, we take it under consideration. We wouldn't be opposed.
Okay.
We have a seat on the Maryland Police Training and Standards Commission, so we would have a voice.
Okay.
in that committee.
Thank you. And if I'm reading this right, it says it's by request of the Baltimore City Administration, but this would have statewide effects. Am I correct?
Yes, it would.
Thank you.
Thank you, sir. Thanks. And with that, that'll end the hearing for Senate Bill 864. We'll now move on to Senate Bill 866, and we'll start off with Mr. Abadir again.
Good to see you all so soon again. Good afternoon. Again, for the record, Adam Abadir, Deputy Director of State Affairs for the Mayor's Office of Government Relations, speaking to him on behalf of the Baltimore City Administration. So Senate Bill 866 is a mayoral priority bill that would exempt the Baltimore City Police Department from state laws and regulations that conflict with the Baltimore City Federal Consent Decree that was entered into prior to January 1st, 2021. Senate Bill 866 would provide flexibility for the Baltimore City Police Department to continue meeting its court-mandated reforms by requiring, in those instances when the United States District Court of Maryland determines there's a conflict between the recommendations set forth by the Federal Consent Decree and state law, that the Federal Consent Decree provision prevails. I'm joined by representatives from the Baltimore City Police Department who can provide more details regarding the specific instances that require this legislation. And also wanted to point out for the committee, after conversations with the Office of the Attorney General, we will be putting forward an amendment that seeks to exempt the Attorney General's office from this legislation. And again, members of the panel will be able to talk to more specifics with that. And so we are respectfully requesting a favorable report with amendments on Senate Bill 866. Thank you.
Good afternoon again, Mr. Chairman, members of the committee. Thank you for allowing me to speak in favor of Senate Bill 866 today. During the last legislative session, you all took on all aspects of police reform. I personally supported and advocated for many smart legislative changes that would allow the BPD to be responsive to community expectations while simultaneously reforming the department in compliance with the consent decree. Unfortunately, some of the provisions that were adopted into law are problematic for Baltimore City because they directly conflict with the mandates of the consent decree and threaten our ability to fully comply with and ultimately be released from that federal decree. There are two provisions that were in HB 670 that will become law later this year and are the most problematic for us. Our bill report provides you with the exact paragraph number and the language from the consent decree, so I'll just touch on it briefly. The first is the requirement that all external complaints must contain the content information of the complainant or the person filing the complaint on behalf of the complainant. While we would love to have the complainant's contact information so that we can speak with them about what they experienced, the reality is that some people are still too afraid to talk to police, even those who are conducting those investigations. That is why our consent decree mandates that we accept and fully investigate all complaints, even if they are anonymous. I'm concerned that if this difference in the language remains, any disciplinary action taken as a result of an anonymous complaint could be challenged in court. The second issue we're concerned about is the statewide disciplinary matrix that all agencies are required to adopt. I agree that having a uniform matrix makes sense so that officers face similar consequences regardless of where they serve. Our concern is that under our consent decree, we are required to submit a disciplinary matrix and to periodically review and amend that matrix. After working with the Department of Justice, the monitoring team, and having multiple opportunities for public input, we have now finalized our matrix. And I'm concerned that if our matrix differs substantially from the matrix it establishes by the MPTSC, we'll have no choice but to either be out of compliance with state law or either out of compliance with the consent decree. For those reasons, I urge a favorable with amendment report on this bill.
Good afternoon. Since we're speaking about police reform, we're just going to provide a very brief update on where we are in Baltimore Police Department's police reform effort, which is through the consent decree. My name is Shannon Sullivan, and I'm the director of the consent decree implementation at the Baltimore Police Department. And I've been with BPD for almost 10 years and have been working on the decree since its inception. And for Baltimore and other agencies under a decree, the requirements ask us to change policy, training, and create systems of accountability so that we can become a self-assessing, self-correcting agency. We are entering the 5th year. And with that, the monitoring team, who works directly for the judge, who provides the federal oversight, produced their first semi-annual report where they were able to go through not just every section of the decree, but paragraph by paragraph of the decree and give us a grade. So of the 31 sections and subsections they reviewed, 77%, are implementation on track. That is the grade they gave us. And when you do the paragraph by paragraph, out of the 420 that they assessed, we have approximately 20% in initial compliance, with 66% also implemented and on track. The remaining are paragraphs that are either still in training or they have not yet assessed, and a few are still in policy development. So that's where we are in terms of our police reform effort. We're making incredible progress. We have more work to do, but that's where we are as we enter year 5. I'm happy to take any questions.
Thank you, Mr. Chair. I appreciate the spirit with which you bring the bill, but I recall that when the consent decree was negotiated by the Baltimore Police Department through the city solicitor in 2016, before, again, Commissioner Harrison, before your time, but specifically it was intentional that the consent decree was explicit that nothing in this consent decree will interfere with the Law Enforcement Officer Bill of Rights or the collective bargaining agreements. And so my point is that the consent decree and the makers of the consent decree, the people that, the stakeholders, were very intentional about that, making it clear that this was not something that would ever interfere or conflict with state law. And so I'm not sure, one, that this is, I guess, necessary, given the way that we started. And then I know Commissioner Harrison, I believe, did point to a couple of things that he felt were in conflict. I'm not really sure, because the Attorney General's letter says that there is no conflict. But I'm not sure if he just meant as pertains to him, but it seems like he's talking generally. So Adam, you talked about, you came to an agreement with him, so do you have any insight on that?
Sure. So we had a conversation with the Attorney General's office, and the Baltimore Police Department's testimony goes into a bit more detail of why the Attorney General specifically is exempted. But it's my understanding of their letter of concern, it was in reference to the way the bill is written, Senate Bill 600 from last year, which there's been some conversation about today already. I want to make sure that the police department has the ability to talk about the agreements that have been reached that make us feel that there is no conflict between the work of the Attorney General's office and independent investigations and the work of the consent decree, but that is separate and distinct from the issues that have been raised around, as Commissioner Harrison raised, when it comes to taking anonymous reports in the disciplinary matrix. So I want to leave it to the Baltimore Police Department to talk a little bit more in detail.
Okay. So when we were drafting the decree, part of the language in section 19 has to do with sort of the administration of the decree. And it does specifically say that it can't, because this language of the decree was drafted after LEOBR, for example, nothing in that decree could change what was already agreed to and something that was already in place. Now, the decree does say if new laws come into effect, the Baltimore Police Department, it's our responsibility to make sure that if there are any new laws or MOUs or, bless you, anything else happening, that it's our best, we have to do the best we can to make sure that it doesn't conflict with the decree, because the decree would have been there before those changes. Does that answer your question? Does that make sense?
It does, somewhat. So the other concern I have, which is definitely in the spirit of promoting something that I think is critically important that the consent decree spoke to, the consent decree also was clear that the existing Civilian Review Board was wholly inadequate and should be empowered in greater ways. And I spent a lot of time before I left the city personally working at ways that the Civilian Review Board could work in better concert with the Baltimore Police Department, information sharing, and so much work went into that. And so now we have a bill before the General Assembly that would help to have the Civilian Review Board better empowered in the spirit of what the consent decree mentioned, and also comply with state law to transition it into the Police Accountability Board. But my concern is that I don't see the support for that part of the consent decree that we're attempting to honor, if you have any comment on that.
We remain open to conversations that we can have to ensure that certain parts of the consent decree, which we have testified as being problematic with certain aspects of the bill, the other bill that you're referencing, we remain open to having those conversations as soon as possible.
Thank you.
Thank you, Mr. Chair. I'm uncomfortable passing a bill that basically says if anybody's able to figure out any conflict between a consent decree and the legislation we passed last year, that our legislation is superseded by the consent decree. Since the consent decree was entered into in 2017, 5 years ago, and then we passed our bill last year, it seems to me somebody ought to be able to go through the two and check the correspondence between the two of them and specifically identify any respects in which they're inconsistent. And then bring those to us, and we could decide in a bill whether or not we want to recede from what we did last year, or whether we want to insist, no, we need to go forward with what we did last year. This bill sort of just escheats to whatever someone down the road decides is inconsistent. So before we sit down to vote on this, could I suggest you will go back and take a hard look at the two documents and come back to us, and if there really is an inconsistency, let us know what it is, and then we can deal with it.
I just wanted to, and I want to make sure that the police commissioner and the representatives of the police department have the opportunity to do this, but that is what this bill is. So we identified, when we were first drafting this, 3 situations that had to be conflicted. Later conversations with the Office of the Attorney General helped us see that one of those things had already been worked out, which is why we were going to submit an amendment to remove that language from the bill. But those other 2 examples that, again, I believe the police department's testimony goes into the specifics around, those are very specific instances where there is that conflict, and that's what this bill is attempting to
Okay,
address.
well, again, if there are specific instances where there's a conflict, we ought to write those instances into this bill, rather than just simply provide in this bill blank check for whatever someone decides later on is inconsistent. See where I'm coming from on this?
I do.
Thanks.
I'm not sure we're voting on this bill this year for what it's worth, but, all right, Senator Cassie, go ahead.
Yeah, I just really briefly, that it's, looking at the bill, it says that if the court determines that provisions is in conflict, so my understanding of the law is that courts don't issue advisory opinion, do not issue advisory opinions. So if a court determines that, a court would only make it determine that if there's a conflict if the court was going to say the federal law stands. I mean, obviously, the federal law has priority or preeminence over us, so if the court says it's in conflict and the federal law stands, then we're all stuck with that. So I'm not sure what we're doing here, because the court would only say that if they were making a decision. There's a conflict, and federal law stands or state law stands. So I'm not getting the purpose of the bill. And then I join my colleague here in just trying to sort of gather, we draft, the entire legislation from last year was led by the senators from Baltimore City. And the whole purpose of it, as I understood it, was police transparency. And now we got Baltimore City coming back in and saying, oh, well, that legislation that's supposedly a model for police transparency, it doesn't comply with what the federal courts are saying we need for police transparency. So I think we need a crosswalk, as Senator West is saying, because somebody's, either the federal courts are giving us a model for police to go forward, or the legislature did. And if one of us didn't, why don't we pick the one that's doing the better job of it and take a look at it? But this just doesn't seem a good way to go. Thank you.
All right. No further questions from the committee. Thank you all very much.
Thank you.
Excellent. Thank you for your time, and thank you for your patience today. All right, we'll now go to the opposition panel, and we'll hear from Mr. Davey.
Good afternoon again. Michael Davey, General Counsel to the State Fraternal Order of Police and General Counsel to Fraternal Order of Police Lodge 3, Baltimore City. On behalf of the entire State Fraternal Order of Police, we would oppose this bill, as we oppose any bill that carves out one police department on a statewide bill. So we would oppose for that. But as it pertains to Fraternal Order of Police Lodge 3, they're absolutely opposed to this bill. The bill really, if you read it, affects two sections. One is the state government article that talked about the independent investigations. I believe there was an amendment, and they're going to strike that from the bill, if I'm correct. The commissioner brought up two other issues. One is the language regarding contact information for complainants, and the other one was the disciplinary matrix. According to the consent decree in paragraph 494, the city and BPD and the DOJ may jointly stipulate to make changes, modifications, and amendments to this agreement which are subject to court approval. So they already, in the consent decree, can make changes, and that's what gives the Baltimore City Lodge 3 the biggest concern. The part about contact information from the complainants can be easily fixed with an amendment to Public Safety Article 3103. And that's the section of the Police Accountability and Discipline section in the law that talks about complaints. The way it reads right now is contact information of the complainant and the person filing on behalf of the complainant for investigation follow-up. Basically, they wanted to be able to contact complainants to follow up on the current status of their investigation. If the information or the complaint is anonymous, there is no contact number. So all that you would have to do is amend 3103B1 small I to add at the very end, comma, if available. And that resolves that issue completely. As it pertains to the disciplinary matrix, they can make an amendment through the courts for the consent decree to change it from the Baltimore Police Department matrix to the statewide matrix. It's not that difficult. If I may, Baltimore City Police biggest concern is actually the language in the consent decree 494 about the ability to make changes. Last year, we spent hours and days on the police accountability bill, how the disciplinary process will work, how it won't work, how it's going to happen for all agencies throughout the state. Taking it to an extreme, because of that modification, the Baltimore Police Department could go to the Department of Justice monitors and go to the judge and say, you know what? The police accountability bill does not work for us. It's just not going to work for us. So we want to change the consent decree and put in our own disciplinary system. And if they can get that approved from the Department of Justice and the judge, the Baltimore Police Department could ignore the entire police accountability bill as it pertains to discipline because the consent decree would supersede state law. And that is a big problem for the Fraternal Order of Police. We worked very hard. We did a lot of concessions last year trying to get that done, and we certainly don't want any one agency to be able to now come back and use the consent decree in order to form their own disciplinary process. Thank you. Stand for any questions.
That was well done. All right, no questions from the committee. Thank you
for
very
your
much. Thanks. All right. So with that, that'll end the hearing for Senate Bill 866. We'll now move on to Senator Beidle with Senate Bill 861. Senator Beidle, welcome.
Mr. Chair, can I bring my panel up? Thank you. Good afternoon, Chair Smith, Vice Chair Wallstreicher, and members of the committee. I'm here to present Senate Bill 861. For the record, I'm Pam Beidle. Senate Bill 861 kind of reestablishes the Maryland State Police Gun Center. It's a statewide gun center, and it's been enforced, but it's not been mandated, and so it's only been staffed by like 3 troopers and 4 civilians with 9,900 calls. What we learned was in 2019, it didn't include this, I'm sorry, in 2021, it did not include the calls from Baltimore City, which were 8,800 crimes of violence, 337 homicides, 7,226 non-fatal shootings in Baltimore City alone. So the estimate is, if we mandate this gun center, it's going to be about 20,000 calls, and that's an estimate from the Maryland State Police that wrote the fiscal note. So Senate Bill 861 provides additional support for the Maryland Gun Center, including increased staffing levels. It is also going to have to include new technology. It's a statewide database to track all crimes committed with firearms. You've heard testimony that ghost guns are expected to be, in a large number in coming years. I think Senator Lee testified to like 1,200 ghost guns, so that's a whole nother issue that needs to be reported. The bill requires all law enforcement agencies to report information on any gun-related crime to the Maryland Gun Center. It enacts a one-stop shop for the screening and vetting of gun cases in Maryland to ensure that offenders are systematically held accountable. One of my panel members is Trooper Tim Fry, who's now retired from State Police, but he was the commander of the state's Firearms Enforcement Center and the principal architect of the Maryland Gun Center. He's still considered the expert on the Maryland Firearms Enforcement Program. During Trooper Fry's time at the Gun Center, it was understaffed and underfunded, but still a very successful program. If we can find a way to properly staff and fund the important asset, it will be more effective going forward as we investigate the use of guns, gun violations, and gun dealers. However, to be truly effective, it must be a statewide database, and it must be financially covered. So we can't mandate it if we're not going to fund it, and I know that's an issue for another committee. If you've not read the Crimes Firearms Study, I put that link in my testimony, but you should. It's a short report, but you really should take the time to read it. And thank you for the opportunity to present Senate Bill 891. I ask for a favorable report so we can reduce gun crimes in Maryland.
Hi, ladies and gentlemen. I am Tim Fry. I am retired Maryland State Police. I'm not here representing the department, but I would like to expound on their fiscal note and encourage you, if you look favorably upon this bill, you have to support it with dedicated resources in the form of money and pins. If the Assembly isn't going to do that, don't do anything. The operation is functional. It's been up and running for 10 years. It provides clarity, precision, and surety to any gun event anywhere in the state 24/7. And if you're going to tack on additional responsibilities, it's going to set the program up for failure. So I would implore you, if you want to increase the gun center, you have to ensure that it gets additional resources in both money and pins. If you have any questions about what the operation is, I'd be happy to answer them. I have a couple more minutes left, but it's been a late day, so I'll yield to the next witness.
I'll be brief as well. Kind of changing gears here. In this particular case, I'm Lieutenant Mike Shire, representing the Anne Arundel County Police, speaking in favor of this bill on behalf of Chief Awad and the Anne Arundel County Police Department. You have Lieutenant Brian Carney from Anne Arundel County Police on your list today as well. He wanted me to extend his apologies. He had a medical issue that needed his attention today. He'll be unable to testify. The Maryland Gun Center is an asset to our state's law enforcement, and it's being underused. By codifying the role of the Gun Center in this bill, our state will be able to fully leverage the information sharing, analysis, and coordination, and tracking of how, where, and by whom firearms are being used to commit crimes in our state. The Gun Center is a fantastic resource for every officer in the state, down to the lowest patrol officer, all the way up to the highest level detectives. And when we need assistance prosecuting crimes involving firearms or 24/7 operation. But requiring all of the agencies to participate in this is extremely important, and this legislation does that so that all of our state's law enforcement officers can better combat and interdict criminal activity involving firearms. As was mentioned, it is extremely important that the funding and staffing for the Gun Center be included in this entire package. We urge this body to make sure that those allocations are made, because without proper staffing and funding, this bill is just ink on paper, and it'll provide no help in stemming the tide of gun violence in this state. So thank you so much for your time, and that'll do it for me.
Thank you, Mr. Chair. I've always assumed that GOCAPS collects and maintains this sort of information. Am I wrong in that?
This information, the report was collected by the Attorney General's office as a result of a bill we passed in 2020. So
Is it correct that GOCAPS doesn't collect this sort of information and
So it's more
maintain
than-
a database of it?
The Gun Center does more than collecting information. It's a 24/7, basically hotline and database tracking system that allows the state police to coordinate gun investigations across the state. Like I said, a police officer on the street at 2 o'clock in the morning who recovers a firearm can call the Gun Center, and they can do a complete workup within minutes and send that information to the officer on, the status of the person they recovered the gun from, whether or not they're prohibited, what charges may or may not be applicable, whether or not the gun is stolen, all these other kinds of things. And then the center, once they have all that information, can use that with this bill, can use that to start connecting dots and draw on broader investigations. And that can all stem from a simple traffic stop on the side of the street or a simple recovery, kind of, building those cases as a fusion center.
Don't
as
get me
opposed to
wrong,
just
I
a
think
database.
this bill's, we definitely need this kind of information. And I love the fact that currently the Gun Center is able to be accessed 24 hours a day. That's terrific, too. It looks to me like the main function of this bill is to require lots of information to be assembled with respect to each gun that's used to commit a crime. And I've assumed that that's what the kind of information that GOCAPS gets. But if I'm wrong on that, then we definitely need this information, and this is a great bill.
I can't speak to what GOCAP is collecting. I do know that the Maryland Gun Center, by having it through the state police, allows it to be easily kind of more at the fingertips, as opposed to kind of an administrative body. It's more of a law enforcement body that's collecting the information.
Great, thank you very much.
Mr. Chair, may I? Senator West, thanks for your question, but remember when I testified that we had 9,900 reports, and as Lieutenant Shire was saying, that was the connecting of guns to people, to crimes, to whether they're licensed. But on top of that, we learned that almost 8,800, almost 12,000 claims were not, or 12,000 reports were not made from Baltimore City. So when you add those to the 9,900, now we're talking about 20,000 reports, and you just can't do that with 3 troopers and 4 civilians, 24 hours a day. Thank you.
A quick question on page 4, lines 7 through 10. It says the center may require a law enforcement agency to report any other information relating to the firearms crimes committed in the jurisdiction of the law enforcement agency to assist the center in the tracking of firearm crimes committed in the state. You know what? Never mind. As I read it,
That's
I
good.
answered my own question.
Thank you, because I left my file back on the chair, so thank you. All right.
Very much. Thank you, Senator Vital. And with that, that'll conclude the hearing for Senate Bill 861. We'll now move on to Senator Heddleman with Senate Bill 819.
Good afternoon, Mr. Chairman, members of the committee. For the record, I'm Shelley Heddleman, and I am here to present Senate Bill 819. And this is actually a really simple bill. All it does is it gives the power to advise and consent from the Senate to the Executive Director of the Governor's Office of Crime Prevention, Youth, and Victim Services. This, and it's a long name, so I'm going to call it the agency formerly known as GOCAP. It has a vision. Its vision is to plan, promote, and fund efforts with government entities, private organizations, and the community to advance public policy, enhance public safety, reduce crime and juvenile delinquency, and serve victims. And that's coming straight from their website. This is an agency that has gone through tremendous change over the past many years. It was created originally as GOCAP in 1995. In 2008, the State Aid for Police Protection came under its purview. In 2011, the State Sexual Assault and Crisis Programs and Domestic Violence Programs was transferred into it. 2018, Victim Services Unit and another sexual assault group came in. In 2020, it was renamed, developed a separate budget code, and the Children's Cabinet was folded into it. It's like a Christmas tree, honestly. It has very interesting, here's my visual aid here, a really interesting org chart. It has a lot of responsibility under its purview. And we have a number of concerns about it. I think a number of people in the legislature, and asked the wonderful folks from the Office of Performance Evaluation and Government Accountability to look at how it was functioning. They produced an over 220-page report that looked at how it was functioning, and one of their recommendations was that we provide advice and consent over the next executive director. This is a department that has grown by over a third since 2017. It has over $200 million within its area of responsibility, and 95% of which are distributed as grants. I'm just going to take one quote from this 200-plus page report. The Governor's Office of Crime Prevention, Youth, and Victim Services core functions and policy areas have grown in recent years. They've expanded from an office mainly administering grants into a large multidisciplinary team covering several functions and policy areas. It now encompasses the prior Governor's Office of Crime Control and Prevention, the prior Governor's Office for Children, and the Victim Services Unit. They have the responsibility to focus on criminal justice and law enforcement, children and youth, and victim services. They are supposed to develop I didn't even know this until I started really digging into this. They're supposed to develop a comprehensive crime plan, advise the governor, coordinate resources between state and local government, administer grants, including state grants, as well as act as a pass-through for federal grants, and they're supposed to analyze crime data. They have faced a lot of challenges, as outlined in this 200-plus page report, and you may hear about some of them today. They have had challenges submitting reports in a timely fashion to this body. We have, over the number of years, asked for a number of different kinds of reports through the Joint Chairman's report, through the budget. They have created a crime plan that has shrunk substantially over the years, both in terms of the actual number of pages as well as in terms of the number of details, and it's gotten more qualitative instead of quantitative. They have not been as transparent in terms of sharing information with the public. A number of their reports are not available on their website. And they have had challenges, as you'll hear from some direct service providers, of communicating grant application procedures and award determinations to the agencies and sub-recipients that they're supposed to be funding. At this time, when public safety is of the utmost importance to the General Assembly and to the public at large, and in light of this tremendous growth and change of the program, the department has experienced over the past number of years, providing the Senate with the opportunity to exercise its role of advice and consent will help to ensure that the agency formerly known as GOCAP's leadership has the requisite skills to address the program's challenges going forward. So I ask for a favorable report on Senate Bill 819, and I will turn it over to my panel. Thank you.
Any order? Thanks so much, Mr. Chairman, and committee members. My name is Mike Powell, and I'm the Director of the Office of Program Evaluation and Government Accountability in the Department of Legislative Services. As a DLS employee, I do not testify for or against any bill. I'm here for informational purposes because in January, as Senator Hedelman said, our office did publish this evaluation. I have 13 hard copies of this giant report here with me, and if any one of you would like to take one with you, I'd be happy to give it to you. So we did that evaluation of, I'll call it GOCAP 2. Our report made the recommendation that the General Assembly consider that the executive director be appointed by the governor and with the advice and consent of the Senate. I'd like to lay out for you the evidence we used to arrive at that recommendation. If there are any questions, the primary author of that report, Tori Hall, is with us today, and she knows this subject matter very well. I'm going to skip over the things that Senator Hedelman already covered. Just to reiterate one thing, though, they have a budget of over $225 million. I believe in the governor's proposed budget for fiscal '23, it's over $300 million. That has grown by a third over the past 5 years. To our knowledge, GOCAP is the largest unit of state government where the legislature lacks even indirect input on the appointment of the leader. So in some cases, leadership reports to a board that might be appointed with the advice and consent of the Senate. This is the largest one we know of where there is no such advice and consent from the Senate. As far as a policy area, I'll wrap up with this. The executive director or their designee serves on more than 30 boards and commissions, chairs at least 7, and directly staffs at least 6. So they have broad kind of hands-on policy related to a bunch of things. All of this is what led us to making the recommendation that we made. I thank you for the time. We're happy to answer any questions.
Embarrassed to say this, but I'd like a copy of that report. There you go.
It's here for you.
There you go. I appreciate it. All right. Ms. Shapiro, you're up.
Good afternoon, Mr. Chairman, members of the committee. Melanie Shapiro with the Maryland Network Against Domestic Violence. I'd like to thank Senator Hedelman for this bill. And while it might not seem very significant, it in fact is for the victim services community. One of the roles that, and I will also call it GOCAP, is that it administers grant dollars. Those are both state and federal grant dollars that go to the victim services community. And this provides everything from operational costs to programmatic costs. And every year, the application process has been delayed. This year, I'll talk about VOCA, which is mentioned a lot in the grant report, understanding that there have been several issues, and they have largely been addressed through a federal fix that needed to be made. But there is a impending budget crisis for victim services community in requiring an incredible amount of state supplemental dollars to offset that temporary reduction. However, there are reserve dollars, and because of the reporting or lack of reporting and lack of transparency within GOCAP, we have no idea how much reserve dollars are. The application process for the VOCA dollars did not even begin, was not even sent out to programs until after this year's fiscal year started. As my prior panelists testified, GOCAP is grown extraordinarily in size, and their budget is larger than 9 of Maryland's 20 principal departments. One of the excellent things about our government system is that we have a system of checks and balances. And this piece of legislation is that necessary check and balance that will provide transparency and accountability to GOCAP and to the people and to the victim services community so that they can understand the process for applying for grant dollars. It can be a seamless process. It could be understood what funds are available, and then once they are granted, where those funds are going. So for all of those reasons, we urge a favorable report on Senate Bill 819.
Good afternoon, Mr. Chairman, Mr. Vice Chair somewhere, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We are also here in support of Senate Bill 819. I'm not going to repeat what's already been said, but I will say, you know, I talked to my colleague in the hall before this hearing, and they talked to me about the vetting process when someone has to go through advice and consent by the Senate. And it is extraordinarily more intense and thorough and thoughtful than someone who doesn't go through this process. And the issues that the Governor's Office of Crime Prevention, Youth, and Victim Services goes through, they handle, they're extraordinarily important. We're talking about rape crisis. We're talking about Maryland Crime Victims Act. We're talking about legal services for crime victims. We're talking about rape crisis centers, domestic violence shelters, child advocacy centers, programs addressing particular populations, survivors of sex crimes. These are issues that I know the members of the Senate care about, and you should have input on who runs the agency that administers these funds. One of the reasons, absolutely, is because they have not been doing as well as they should. And I do want to just make it clear that this is not a partisan issue. This is something that has gone on for several administrations. So I don't want anyone to feel like we are standing here saying that this is particular to Governor Hogan. It is not. This is something that really is an agency that's experienced tremendous growth without enough oversight. And when you all are trying to exercise the oversight that you have every right to exercise, they're just ignoring you. They're not filing reports, they're not doing the audits, they're not providing the information, and you're hampered by this. This is one way that you can exercise more control over what's going on in the state of Maryland with victim services. For those reasons, the Maryland Coalition Against Sexual Assault asks for a favorable report on Senate Bill 819.
Thank you, Mr. Chair. You might be surprised to hear that I think this is a really good bill, but I'm not sure it goes far enough. Someone mentioned that there's no board or no advisory committee. There are lots of other organizations that are not cabinet organizations that have these committees of independently appointed people, including a couple of senators, a couple of delegates, to sort of oversee what's going on. Seems to me we should add that for GOCAPS, given the size and importance of the function. And the other thing, it seems to me, is we should have an annual report from GOCAPS, which discloses all these grants that they've made, what were the amounts of the grants, who did they make the grants to, so it's not just hidden away in GOCAPS's files, but it's available to the public. But thank you very much for bringing the bill to Senator Hedelman.
So, Senator, since you were looking at me, I'll go ahead and answer that and stand up so I can still see Senator Sidner around the podium there. You know, you are absolutely, completely right. I think that one thing that we are thinking about is that the governor's seat will change and there may be some reorganization. So although I completely agree with you, and I think it reflects some of the recommendations that are also in the report, particularly that annual report, the transparency, the gathering together and coordinating the multiple reports that are made, all of those things are important. But I would hate to see this get bogged down with so many details that it didn't pass when this is such an important first step. So, you know, certainly the will of the committee, I think, on this is as important as always, but please don't sacrifice this bill by too many details and then we can't get it through by sine die.
I just had a question for to Mr. Powell, just so we get an idea of scope, and I'm sure this is in the report, but what is the next largest agency that does not require that appointment approval from the?
I believe it's the Department of the Military.
Okay.
And then there's one that Tori may recall that's right after that. They are in the $200 million a year budget range. They may have higher personnel. I mean, GOCAP is a small personnel, large budget agency because of the nature of what they do. 95% of the money that they spend is disperses grants.
Yeah.
Do you have the second one?
Yeah, we compared it to both the principal departments of the state and also to the independent agencies. So Mr. Powell was referring to the independent agencies. All of the largest of those independent agencies are under Senate advice and consent. The Military Department and Maryland Energy Administration, which are significantly smaller, less than half in size, they are also appointed by the governor. And also the State Department of Assessments and Taxation is appointed by the governor. but that's also
Without-
smaller than GoCap.
Without advice and consent.
Understood. Got it. That's important. Thanks. Yeah, I'll definitely, I've got to admit, I haven't read the report and I didn't say, oh, this is great. Thank you all. Yeah, I think he's got 13 copies.
Could I leave it back there?
Absolutely, that'd be great. Thank you so much.
Happy
This
to do so.
would be very helpful. Seeing no further questions from the committee, thank you all very much, and thank you for your patience today, hanging in here with us. And with that, that'll conclude the testimony and the hearing for Senate Bill 819. We'll now move on to, so we're going to skip over to see Senator Jackson's here. So we're going to go to Senator Jackson with Senate Bill 752.
Afternoon, Mr. Chairman, members of the Judicial Proceedings Committee. For the record, Senator Michael Jackson, representing District 27, on behalf of Senate Bill 752. Senate Bill 752 is a very straightforward bill that requires the reporting and publishing of the use of force data for Maryland police agencies. The bill would require two types of reporting. Beginning on or before July 1, 2024, agencies will be required to publish aggregate data related to use of force incidents on their public websites. Secondly, beginning on or before January 1st, 2023, and every 3 months thereafter, agencies will be required to publish total numbers of use of force incidents on their public websites. The data that agencies will be required to collect would include the following items: type of encounter in which the force was used, type of force used, geographic location of which force was used. Mr. Chairman and members, the fourth item that's listed in the bill will be amended out of the bill. That deals with the justification. We're amending that out of the bill for obvious reasons. Whether the agency deemed the force justified, whether the person against whom force was used was arrested, whether the person against whom force was used required medical care, whether the officer required medical care, and demographic information. One second. As you know, from my professional background as an officer, as a union leader, and as a sheriff of my county, I think it's we have over the decades systematically lost the public's trust. This is just what I believe, Mr. Chairman, is another measure of bringing back transparency and accountability within our law enforcement agencies. It's a piece of legislation that can help all of us going forward. It can help the public believe in us again and help the agency get back to being accountable for the services we provide. We discussed these issues repeatedly over the last year when I served with this body, and as in 2016 as a member of the Public Safety and Police Work Group. I will reiterate what I've said on the floor when I was in the House and here. Look, I think the criminal justice system is a five-legged stool, and we are still focusing on police reform, and that's fine. But I think we need to look at the true aspects of, and from a holistic approach, of what that really means. And it means transparency and accountability throughout our entire criminal justice system. So with that, I'd ask for a favorable report on this piece of legislation. And Mr. Chairman, I'm willing to work with the committee on any challenges that you may see. But I think this is a piece of legislation that's akin to last year we had the law enforcement officer shooting toward the end of the session that we brought up. Same thing. It's a reporting bill. So I'll stand for questions.
Explain to me the issue that the Maryland Sheriff's Association spoke of related to acknowledging disability status?
Well, yes. So the first was dealing with the justification, which I wholeheartedly believe because, the investigation takes care of that. I think oftentimes we sort of step back from the demographics on the disability component, but those are matters that basic questions during incident reports, just to get the basic information is enough. I'm really not sure why that's still an issue with them. But as a law enforcement guy, as a union guy, and as a sheriff, I don't see an issue with that. That's just basic demographic information, so. But again, willing to work with you in any capacity, but I think, together, we can get where we need to get, the more transparent we can be. And I don't have a panel. I didn't hear what you said, Mr. Chairman, before. Oh, okay. But I know there are a number of folks.
She signed up as favorable.
Yep.
There you go.
Thank you all very much.
All right. Thank you. Thank you, Senator.
Yep.
All right.
And Mr. Chairman, check your text message.
Will do.
And Senator Huff, check your text message. There's a commission meeting tomorrow morning.
Got it.
Good afternoon again, Chairman Smith and members of the committee. For the record, Krista Williams, Director of the Government Relations Division for the Office of the Public Defender. I'm here today in support of SB 752, as we see this bill as an important component to continued efforts to increase transparency and further enhance important comprehensive criminal justice and policy reform measures. As we all know, last year was the year of sweeping police reform, and this is the year for two responses: one, to fix what has not been working well, and two, to take back power or pass laws that negate this body and the public's mandates of the last session. And so we must remain vigilant on all policing reform bills and pay close attention to the experts in the fields seeking to clarify, to improve, and to make legislation effective on the ground. Incident reports, use of force reports, the Attorney General's bill, and the body camera bills that we all heard about today are derived from experts in the field doing their best to see the legislature's mandate through to success. And for those reasons, we are in full support of this bill and ask for a favorable report. Thank you.
All right, thank you very much. And with that, that'll conclude the hearing for Senate Bill 752. Thank you, Senator Jackson. Thank you, Ms. Williams. All right, we'll now move on to the final bill of the day, Senator Waldstreicher, and that'll be Senate Bill 881. And Senator Waldstreicher is attending to a personal matter today, so we'll start off Ms. Wiesel, and then we'll go to Mr. Sanderson.
Thank you, Mr. Chairman. It's like the good old days being here till the very end. But good to see everybody in person. For the record, Meredith Wiesel, the Regional Director of ADL, the Anti-Defamation League's DC office. This is a bill that we actually had 2 years ago in 2020 that unfortunately, due to the world of everything shutting down and stuff, it unfortunately wasn't able to make it through. But it's still relevant. We decided to hold off last year to kind of rewrite some of it. This is related to swatting. And you've had a couple of bills, I know, that have come before this committee that are similar. This is a much more comprehensive, specifically addressing the issue of swatting, where it's not just somebody calling in a false call to law enforcement. It potentially could be coming from online as well, which is where we've been seeing this happen a lot in the past recent years. And I also just want to thank all the co-sponsors of the bill, particularly those of you who are actually on this committee. As we're we've been looking at this, and we've been looking at the incident of swatting and stuff, it's becoming an increasing tool that we're seeing as part of digital harassment tactic, and we really need to figure out ways to protect vulnerable groups more against the actions of online hate, the phone calls that are being made to law enforcement, because it's having real consequences on the ground. There are several incidents that have actually happened in Maryland over the past few years, and we're happy to provide the examples for those. But the bottom line is it's creating a 911 hoax with the goal of sending the emergency responders out to another's. Usually it's somebody's dwelling. Sometimes it's been somebody's place of business and stuff. And a lot of these details are in our written testimony. But this bill is a comprehensive approach to addressing the issue of swatting. And I do want to also point out Senator Carter's bill, which it has already moved through the Senate, which is fantastic, talking about hate crimes related to making a false statement to an officer, is a tool related to this, but it's not directly to swatting. It's what actually usually happens when somebody's in person. So this is just another element of that we're continuing to see. And with that, we'd ask for a favorable report. Thank you.
Thank you, Mr. Chair. Members of the committee, I'm Michael Sanderson with the Maryland Association of Counties. We submitted a written statement in support of the bill. We've supported a couple different bills before the committee trying to get to this general issue. Frequently, I'll say things like, some stuff in the testimony talks about this is a waste of resources and this is a burden on the administration of law enforcement agencies. I think those are good reasons to support this bill, but they're by far the least important reasons to support this bill. Someone's going to get killed with one of these incidents. That this is interference with the conduct of public business and with the ability to do police work and law enforcement in your community. But it's just a matter of time till somebody decides to pull a prank on someone they're upset with because of something that happened in a video game or someone's tree limb fell on their car or whatever. Someone's going to get called. Folks are going to come in guns a-blazing, and either someone who's part of the law enforcement response or the person who's the victim of swatting is going to get killed from one of these incidents. We got to take this seriously. The specifics aside, you've got multiple tools before you. This bill's a good one. You got other ones that are a good one. But on behalf of our first responders and the people who are victims of this kind of tool, this is a big and growing problem. Let's tackle it somehow. Thank you.
Yeah, just a quick question. I was curious, what's the difference between this bill and then I know Senator Kagan had one too?
Yeah, so, is it on? Okay. So this is a little bit more comprehensive, and this specifically goes to the reckless disregard of causing bodily harm to an individual as a direct result, and so it has very specific penalties. And if you look through the bill, I don't have the bill in front of me, but the different numbers, depending on what the severity of it is, and especially if it results in death as well, it has different penalties and different levels in there. So it's a little bit more comprehensive than Senator Kagan's bill. And I do also want to, this actually has resulted in death. There is a case where law enforcement was called in DC, and there was a victim who actually died in Kansas as related to this. So that has actually happened as well. But this, we've been working on this, the Anti-Defamation League in actually all the states and looking at swatting, a comprehensive swatting bill. The most recent one passed in 2020 in Washington State that the governor then signed, and this is modeled similar to that. So it's a little bit more comprehensive than Senator Kagan's bill.
If I could give a very quick response also, just in Senator Kagan's bill, Senator Kagan's worked very closely with the 911 community specifically. Yeah. There's an element in her bill that's a little bit broader, I think, on the nature of the offense. Her bill speaks not just to like swatting in the way it's been described for this bill, but also to I think the term of art is a digital denial of service. The idea of let's generate a bunch of phony phone calls to the 911 center and render them incapable of receiving and handling proper phone calls. That bill deals with that
Or
as
like
well
a
as this bill.
cyber, or more like a cyber crime versus.
Very much so.
Yeah, and it doesn't always then send a SWAT team out. This is specifically calling somebody and saying, you need to come, so-and-so is doing X, Y, and Z, and you need to come to their house. It actually happened to Wolf Blitzer, who lives in Maryland, as you all know, back in 2013. He and his wife happened to actually not be home at the time, but somebody called out and a SWAT team showed up at his house, and there was nothing actually going on there. So it was a waste of resources. But I do want to point out this has also caused harm, particularly to a lot of our marginalized communities, because we're actually seeing it as a tactic used by a lot of extremist groups out there. There's a group that's called Anawaffen, and it was back in Virginia. I think it was in 2021. Sorry, my years are sometimes lost here. In 2021, where they specifically started calling people out to a couple of black churches in the area, and they were doing it through digital methods and through voice calls to 911.
Okay.
See the chiefs and sheriffs support with the amendment. What's your response to their proposed amendment to remove the provision that exempts juvenile, well, for juveniles' first offense, it's de minimis?
Yeah, so I did talk, first of all, the Maryland State's Attorneys also does support this. They weren't able to be here, but I did talk with them because they supported it 2 years ago, and I did talk with the Maryland Chiefs and Sheriff's Association. Our position is, look, I understand where they're coming from and stuff, but the reality is that a lot of times when a juvenile is doing this, I don't want to say that it's a prank, but it usually is, it can be in many ways. And given that the legislature in general has kind of looked a lot at juvenile justice reform, we'd prefer it, at least for now, to keep it the way it is drafted and keep it as a civil offense, at least for right now.
But
and there haven't been that many cases with juveniles.
And their concern was look, this would go to juvenile services, and if it's a first offense, probably nothing at all would happen. But what happens when it's the juvenile who's 17 who calls it in, and as a result of that, 3 people die? And we'll say, well, the result for that is the civil penalty of $100. I mean, it just seems like in those cases,
Sure.
that would just be just an egregious miscarriage of justice.
Yeah, I mean, look, I can certainly understand that. We haven't seen that many cases that have happened, at least at this point in time.
It only takes one, where the
I
3 people die.
I totally understand, and I think the prerogative of the legislature, if the committee wants to certainly look at that as an amendment, and I think if it is something, if this bill was to pass, we'll get to come back, in previous years or, in years to come, possibly. For now, though, we prefer it to be the way it is, based on the analysis that we've been able to do over the past several
thank you.
years.
Further questions? Thank you both very much. And with that, that will conclude the testimony for Senate Bill 881 and the hearings for the day. So let's take a 10-minute break, and we'll come back, we'll vote. We're going to vote on the Judicial Transparency Bill and then Senator West's bills that were on the list last time that we were unable to get to. Oh.
It'll be coming out. It's.
Yeah, we'll discuss it. I mean, get through it. Yeah. Yeah. Can we get to them?
I mean, they're.
All right, so we'll do 10 minutes. 10 minutes, we'll vote.